to go back and look at it. The position now is that let's presumptively injunct the situation. And the string of authorities that have been before this court, starting from the Welfare Kwaku to Ransford France to Haruna Idrisu and
no, Mr. Sorry.
Yes,
Mr. Sorry. If you want to cite a case, kindly do so that we can consider it.
Oh, very well.
You know, for instance, Welford Kwaku was cited.
Yes.
Ransford France. So if you want to add to the cases, do so.
There is Haruna Idrisu and two others, which even makes. Yes. It is writ number J1/9.
Is this the e-levy matter?
E-levy matter. I can cite it as such unless you give me leave.
That matter has not been settled. It's only...
No, that was an injunction application that came before the court.
Wait. All right. So you are referring to the ruling on the injunction?
Injunction, yes. In which the court even applied the presumption of regularity. There is in the Bugri number 1 versus Attorney General also. It's 2013 to 2014, 2 in the Bugri number 1. (2013 to 2014) 2 Supreme Court of Ghana law reports at page 1134.
Repeat the citation. I was consulting with my brothers.
It's 2013 to 2014, 2 Supreme Court of Ghana law reports at page 1134. There's even Attorney General versus Commission on Human Rights and Administrative Justice number 2. 1998 to 99, Supreme Court of Ghana law reports at page 894. My lords, and I want to refer my lord to some submission also that was because I'm on the line of authorities. Let me deal with the arguments on the line of authorities. They compare the situation to the Ghana Independent Broadcasting case cited by the plaintiff and the first defendant, in which an LI was placed before Parliament and an injunction was granted to restrain its ripening into law. The biggest difference, and I'm glad...
An injunction was granted or injunction was applied for?
It was applied for and granted. The biggest difference in this particular case is the point that I've been making earlier on, that in that particular case, it was subsidiary legislation. After the gestation period of 21 days, it ripens into law. It doesn't come back. So that was an imminent danger. It was an imminent danger. It was likely to happen. In this particular case, it's a very remote danger. The remoteness is that the first defendant against whom I'm arguing...
Is there danger? Is there danger? I keep bringing you back to it. If there's danger, acknowledge that there's danger.
There is no danger.
Go and remove the danger.
At the moment,
because this is in your remit. Go and remove. Go and fix it. And if there isn't danger, tell us that there's no danger.
There is no danger at all. In fact, the danger is far, if there was any, it was removed even by the Attorney General, who in this court reminded us that he's the principal advisor of government. The thing is coming before him to decide whether you are sent or not. Take it back, say, under the law, I require you to look at it. So there's no danger at all. He has full control over that process. And he should take control of it rather than leave than call for the court to assist him. So, Ghana Independent Broadcasting Corporation, in which the injunction was granted, doesn't apply. Then there is Michael Akuma Nimfa versus Judge Kwesi, which was also cited. If my laws take a critical look at that decision, my laws won't apply it, and I'll give a reason. That case relied on too many cases involving private matters, injunction, Pujabi and Ami, and all of that. There was no focus on the clear grounds on which this court grants.
Which case is that?
Michael Jachukwesi. It was
No, I recall. I was very much in that matter. That case was premised on the point that
there, Titus Sorry, lawyer to the Speaker of Parliament. Now, they were debating some key issues. The CJ, they're grilling him for answers. Lawyer for Amanda Odoi, Ernest Yao Ako, filed an interlocutory injunction restraining Parliament from transmitting the bill to the President for assent or otherwise. Now, his basis is that this bill is a private member's bill and it will impose some sort of charge on the public purse. Now, they argue that per the dictates of Article 108 of the 1992 Constitution, Parliament is constrained. His view is that such a bill should emanate from the presidency, and that's the challenge as we speak, where the AG took the floor, gave his submission, and then Titus Sorry took the floor explaining his own side of the deal. He speaks for the Speaker of Parliament, and so the contention here is that has there been a breach of the Article 108 of the 1992 Constitution? That's where the debate is at right now, and we're going to be in court all day. We're taking a quick breather. We'll be back with more. Do stay tuned in.
Deposit and maintain a minimum balance of 500 Ghana cedis or multiples of it to qualify to win your share of 1.2 million Ghana cedis in cash and prizes. EMG. Join the EcoBank Million Gang. A better way to enjoy life. Deposit today. A better way. A better Africa. EcoBank. The Pan-African Bank.
These LPG stations, do they even have permits to run?
LPG stations are safer now than ever. We are duly licensed and fully regulated by the National Petroleum Authority, with full support from the Ghana Fire Service, Ghana Standards Authority, Factory Inspectorate, as well as the EPA. So why worry?
Is it true that these LPG stations are really owned by Ghanaians?
Oh yes. By refilling your gas cylinders with us, you're also supporting local businesses. Sikano, Ekeya.
Oh yes. Protect local businesses by refilling your gas cylinders at LPG stations nationwide.
Hey, Della, are you sure you can carry both?
This one there is Coco Cra.
Owning a home is
which is accepted as truth and accuracy every day, is accessible on the go. Access your favorite daily graphic and our weeklies The Mirror, Graphic Business, Graphic Showbiz, Junior Graphic, and Graphic Sports on Graphic News Plus app. It's the digital replicas of our work. Download Graphic News Plus app on the Google Play Store, Apple App Store, and available on www.graphicnewsplus.com as you remain abreast of and keep pace with on-the-minute news updates on the go. Home sweet home. Welcome family and friends. Choose the bundle that best works for you from as low as 10 Ghana cedis weekly for unlimited access to all publications. Graphic, truth and accuracy every day. Information is a great source of power, adding to your options, knowing that quality and standard remains intact, and our content, which is accepted as truth and accuracy every day, is accessible on the go. Access your favorite daily graphic and our weeklies The Mirror, Graphic Business, Graphic Showbiz, Junior Graphic, and Graphic Sports on Graphic News Plus app. It's the digital replicas of our work. Download Graphic News Plus app on the Google Play Store, Apple App Store, and available on www.graphicnewsplus.com as you remain abreast of and keep pace with on-the-minute news updates on the go. Home sweet home. Welcome family and friends. Choose the bundle that best works for you from as low as 10 Ghana cedis weekly for unlimited access to all publications. Graphic, truth and accuracy every day. Information is a great source of power, adding to your options, knowing that quality and standard remains intact, and our content, which is accepted as truth and accuracy every day, is accessible on the go. Access your favorite daily graphic and our weeklies The Mirror, Graphic Business, Graphic Showbiz, Junior Graphic, and Graphic Sports on Graphic News Plus app. It's the digital replicas of our work. Download Graphic News Plus app on the Google Play Store, Apple App Store, and available on www.graphicnewsplus.com as you remain abreast of and keep pace with on-the-minute news updates on the go. Home sweet home. Welcome family and friends. Choose the bundle that best works for you from as low as 10 Ghana cedis weekly for unlimited access to all publications. Graphic, truth and accuracy every day. Information is a great source of power, adding to your options, knowing that quality and standard remains intact, and our content, which is accepted as truth and accuracy every day, is accessible on the go. Access your favorite daily graphic and our weeklies The Mirror, Graphic Business, Graphic Showbiz, Junior Graphic, and Graphic Sports on Graphic News Plus app. It's the digital replicas of our work. Download Graphic News Plus app on the Google Play Store, Apple App Store, and available on www.graphicnewsplus.com as you remain abreast of and keep pace with on-the-minute news updates on the go. Home sweet home. Welcome family and friends. Choose the bundle that best works for you from as low as 10 Ghana cedis weekly for unlimited access to all publications. Graphic, truth and accuracy every day. Information is a great source of power, adding to your options, knowing that quality and standard remains intact, and our content, which is accepted as truth and accuracy every day, is accessible on the go. Access your favorite daily graphic and our weeklies The Mirror, Graphic Business, Graphic Showbiz, Junior Graphic, and Graphic Sports on Graphic News Plus app. It's the digital replicas of our work. Download Graphic News Plus app on the Google Play Store, Apple App Store, and available on www.graphicnewsplus.com as you remain abreast of and keep pace with on-the-minute news updates on the go. Home sweet home. Welcome family and friends. Choose the bundle that best works for you from as low as 10 Ghana cedis weekly for unlimited access to all publications. Graphic, truth and accuracy every day. Information is a great source of power, adding to your options, knowing that quality and standard remains intact, and our content, which is accepted as truth and accuracy every day, is accessible on the go. Access your favorite daily graphic and our weeklies The Mirror, Graphic Business, Graphic Showbiz, Junior Graphic, and Graphic Sports on Graphic News Plus app. It's the digital replicas of our work. Download Graphic News Plus app on the Google Play Store, Apple App Store, and available on www.graphicnewsplus.com as you remain abreast of and keep pace with on-the-minute news updates on the go. Home sweet home. Welcome family and friends. Choose the bundle that best works for you from as low as 10 Ghana cedis weekly for unlimited access to all publications. Graphic, truth and accuracy every day. Information is a great source of power, adding to your options, knowing that quality and standard remains intact, and our content, which is accepted as truth and accuracy every day, is accessible on the go. Access your favorite daily graphic and our weeklies The Mirror, Graphic Business, Graphic Showbiz, Junior Graphic, and Graphic Sports on Graphic News Plus app. It's the digital replicas of our work. Download Graphic News Plus app on the Google Play Store, Apple App Store, and available on www.graphicnewsplus.com as you remain abreast of and keep pace with on-the-minute news updates on the go. Home sweet home. Welcome family and friends. Choose the bundle that best works for you from as low as 10 Ghana cedis weekly for unlimited access to all publications. Graphic, truth and accuracy every day. Information is a great source of power, adding to your options, knowing that quality and standard remains intact, and our content, which is accepted as truth and accuracy every day, is accessible on the go. Access your favorite daily graphic and our weeklies The Mirror, Graphic Business, Graphic Showbiz, Junior Graphic, and Graphic Sports on Graphic News Plus app. It's the digital replicas of our work. Download Graphic News Plus app on the Google Play Store, Apple App Store, and available on www.graphicnewsplus.com as you remain abreast of and keep pace with on-the-minute news updates on the go. Home sweet home. Welcome family and friends. Choose the bundle that best works for you from as low as 10 Ghana cedis weekly for unlimited access to all publications. Graphic, truth and accuracy every day. Information is a great source of power, adding to your options, knowing that quality and standard remains intact, and our content, which is accepted as truth and accuracy every day, is accessible on the go. Access your favorite daily graphic and our weeklies The Mirror, Graphic Business, Graphic Showbiz, Junior Graphic, and Graphic Sports on Graphic News Plus app. It's the digital replicas of our work. Download Graphic News Plus app on the Google Play Store, Apple App Store, and available on www.graphicnewsplus.com as you remain abreast of and keep pace with on-the-minute news updates on the go. Home sweet home. Welcome family and friends. Choose the bundle that best works for you from as low as 10 Ghana cedis weekly for unlimited access to all publications. Graphic, truth and accuracy every day. Information is a great source of power, adding to your options, knowing that quality and standard remains intact, and our content, which is accepted as truth and accuracy every day, is accessible on the go. Access your favorite daily graphic and our weeklies The Mirror, Graphic Business, Graphic Showbiz, Junior Graphic, and Graphic Sports on Graphic News Plus app. It's the digital replicas of our work. Download Graphic News Plus app on the Google Play Store, Apple App Store, and available on www.graphicnewsplus.com as you remain abreast of and keep pace with on-the-minute news updates on the go. Home sweet home. Welcome family and friends. Choose the bundle that best works for you from as low as 10 Ghana cedis weekly for unlimited access to all publications. Graphic, truth and accuracy every day. Information is a great source of power, adding to your options, knowing that quality and standard remains intact, and our content, which is accepted as truth and accuracy every day, is accessible on the go. Access your favorite daily graphic and our weeklies The Mirror, Graphic Business, Graphic Showbiz, Junior Graphic, and Graphic Sports on Graphic News Plus app. It's the digital replicas of our work. Download Graphic News Plus app on the Google Play Store, Apple App Store, and available on www.graphicnewsplus.com as you remain abreast of and keep pace with on-the-minute news updates on the go. Home sweet home. Welcome family and friends. Choose the bundle that best works for you from as low as 10 Ghana cedis weekly for unlimited access to all publications. Graphic, truth and accuracy every day. Information is a great source of power, adding to your options, knowing that quality and standard remains intact, and our content, which is accepted as truth and accuracy every day, is accessible on the go. Access your favorite daily graphic and our weeklies The Mirror, Graphic Business, Graphic Showbiz, Junior Graphic, and Graphic Sports on Graphic News Plus app. It's the digital replicas of our work. Download Graphic News Plus app on the Google Play Store, Apple App Store, and available on www.graphicnewsplus.com as you remain abreast of and keep pace with on-the-minute news updates on the go. Home sweet home. Welcome family and friends. Choose the bundle that best works for you from as low as 10 Ghana cedis weekly for unlimited access to all publications. Graphic, truth and accuracy every day. Information is a great source of power, adding to your options, knowing that quality and standard remains intact, and our content, which is accepted as truth and accuracy every day, is accessible on the go. Access your favorite daily graphic and our weeklies The Mirror, Graphic Business, Graphic Showbiz, Junior Graphic, and Graphic Sports on Graphic News Plus app. It's the digital replicas of our work. Download Graphic News Plus app on the Google Play Store, Apple App Store, and available on www.graphicnewsplus.com as you remain abreast of and keep pace with on-the-minute news updates on the go. Home sweet home. Welcome family and friends. Choose the bundle that best works for you from as low as 10 Ghana cedis weekly for unlimited access to all publications. Graphic, truth and accuracy every day. Information is a great source of power, adding to your options, knowing that quality and standard remains intact, and our content, which is accepted as truth and accuracy every day, is accessible on the go. Access your favorite daily graphic and our weeklies The Mirror, Graphic Business, Graphic Showbiz, Junior Graphic, and Graphic Sports on Graphic News Plus app. It's the digital replicas of our work. Download Graphic News Plus app on the Google Play Store, Apple App Store, and available on www.graphicnewsplus.com as you remain abreast of and keep pace with on-the-minute news updates on the go. Home sweet home. Welcome family and friends. Choose the bundle that best works for you from as low as 10 Ghana cedis weekly for unlimited access to all publications. Graphic, truth and accuracy every day. Information is a great source of power, adding to your options, knowing that quality and standard remains intact, and our content, which is accepted as truth and accuracy every day, is accessible on the go. Access your favorite daily graphic and our weeklies The Mirror, Graphic Business, Graphic Showbiz, Junior Graphic, and Graphic Sports on Graphic News Plus app. It's the digital replicas of our work. Download Graphic News Plus app on the Google Play Store, Apple App Store, and available on www.graphicnewsplus.com as you remain abreast of and keep pace with on-the-minute news updates on the go. Home sweet home. Welcome family and friends. Choose the bundle that best works for you from as low as 10 Ghana cedis weekly for unlimited access to all publications. Graphic, truth and accuracy every day. Information is a great source of power, adding to your options, knowing that quality and standard remains intact, and our content, which is accepted as truth and accuracy every day, is accessible on the go. Access your favorite daily graphic and our weeklies The Mirror, Graphic Business, Graphic Showbiz, Junior Graphic, and Graphic Sports on Graphic News Plus app. It's the digital replicas of our work. Download Graphic News Plus app on the Google Play Store, Apple App Store, and available on www.graphicnewsplus.com as you remain abreast of and keep pace with on-the-minute news updates on the go. Home sweet home. Welcome family.
Again, another last point is that indeed the cases that my dear friend indicated that concern themselves with the introduction of an ally in Parliament, and it's urging on the court the fact that those cases related to the introduction of an ally in Parliament, and for that matter, they are different from this one. Really, the difference is, with all respect, does not arise at all. There's no difference at all. They all have to do with laws passed by Parliament, or laws that were supposed to be dealt with by Parliament. And indeed, an ally or a statutory legislation forms part of the body of laws in Article 11, Clause 7 of the Constitution. Article 11, Clause 1, respectively, of the Constitution.
Eji, what he said was that because he used the word danger, because after 21 days it was going to ripen into a full law. So there was a danger, let me quote it, danger, irreparable damage when 21 days passed and then it will ripen into a law. That was why they injuncted the process.
Mr. Philip, there's no such danger at all, because Article 11, Clause 7 actually also imposes on Parliament a remedy. Parliament has the power to annul such a bill. So there's no such danger at all. Very respectful. Very respectful.
Or submissions. The court will rise for a few minutes.
You may resume your seats, or you can stretch.
Which is accepted as truth and accuracy every day, is accessible on the go. Access your favorite daily graphic and our weeklies The Mirror, Graphic Business, Graphic Showbiz, Junior Graphic, and Graphic Sports on Graphic News Plus app. It's the digital replicas of our work. Download Graphic News Plus app on the Google Play Store, Apple App Store, and available on www.graphicnewsplus.com as you remain abreast of and keep pace with on-the-minute news updates on the go. Home sweet home. Welcome family and friends. Choose the bundle that best works for you from as low as 10 Ghana cedis weekly for unlimited access to all publications. Graphic, truth and accuracy every day. Information is a great source of power, adding to your options, knowing that quality and standard remains intact, and our content, which is accepted as truth and accuracy every day, is accessible on the go. Access your favorite daily graphic and our weeklies The Mirror, Graphic Business, Graphic Showbiz, Junior Graphic, and Graphic Sports on Graphic News Plus app. It's the digital replicas of our work. Download Graphic News Plus app on the Google Play Store, Apple App Store, and available on www.graphicnewsplus.com as you remain abreast of and keep pace with on-the-minute news updates on the go. Home sweet home. Welcome family and friends. Choose the bundle that best works for you from as low as 10 Ghana cedis weekly for unlimited access to all publications. Graphic, truth and accuracy every day. Information is a great source of power, adding to your options, knowing that quality and standard remains intact, and our content, which is accepted as truth and accuracy every day, is accessible on the go. Access your favorite daily graphic and our weeklies The Mirror, Graphic Business, Graphic Showbiz, Junior Graphic, and Graphic Sports on Graphic News Plus app. It's the digital replicas of our work. Download Graphic News Plus app on the Google Play Store, Apple App Store, and available on www.graphicnewsplus.com as you remain abreast of and keep pace with on-the-minute news updates on the go. Home sweet home. Welcome family and friends. Choose the bundle that best works for you from as low as 10 Ghana cedis weekly for unlimited access to all publications. Graphic, truth and accuracy every day. Information is a great source of power, adding to your options, knowing that quality and standard remains intact, and our content, which is accepted as truth and accuracy every day, is accessible on the go. Access your favorite daily graphic and our weeklies The Mirror, Graphic Business, Graphic Showbiz, Junior Graphic, and Graphic Sports on Graphic News Plus app. It's the digital replicas of our work. Download Graphic News Plus app on the Google Play Store, Apple App Store, and available on www.graphicnewsplus.com as you remain abreast of and keep pace with on-the-minute news updates on the go. Home sweet home. Welcome family and friends. Choose the bundle that best works for you from as low as 10 Ghana cedis weekly for unlimited access to all publications. Graphic, truth and accuracy every day. Information is a great source of power, adding to your options, knowing that quality and standard remains intact, and our content, which is accepted as truth and accuracy every day, is accessible on the go. Access your favorite daily graphic and our weeklies The Mirror, Graphic Business, Graphic Showbiz, Junior Graphic, and Graphic Sports on Graphic News Plus app. It's the digital replicas of our work. Download Graphic News Plus app on the Google Play Store, Apple App Store, and available on www.graphicnewsplus.com as you remain abreast of and keep pace with on-the-minute news updates on the go. Home sweet home. Welcome family and friends. Choose the bundle that best works for you from as low as 10 Ghana cedis weekly for unlimited access to all publications. Graphic, truth and accuracy every day. Information is a great source of power, adding to your options, knowing that quality and standard remains intact, and our content, which is accepted as truth and accuracy every day, is accessible on the go. Access your favorite daily graphic and our weeklies The Mirror, Graphic Business, Graphic Showbiz, Junior Graphic, and Graphic Sports on Graphic News Plus app. It's the digital replicas of our work. Download Graphic News Plus app on the Google Play Store, Apple App Store, and available on www.graphicnewsplus.com graphic-news+.com as you remain abreast of and keep pace with on-the-minute news updates on the go. Home sweet home. Welcome family and friends. Choose the bundle that best works for you from as low as 10 Ghana cedis weekly for unlimited access to all publications. Graphic, truth and accuracy every day. Information is a great source of power, adding to your options, knowing that quality and standard remains intact and our content, which is accepted as truth and accuracy every day, is accessible on the go. Access your favorite daily graphic and our weeklies The Mirror, Graphic Business, Graphic Showbiz, Junior Graphic, and Graphic Sports on Graphic News Plus app. It's the digital replicas of our work. Download Graphic News Plus app on the Google Play Store, Apple App Store, and available on www.graphicnewsplus.com as you remain abreast of and keep pace with on-the-minute news updates on the go. Home sweet home. Welcome family and friends. Choose the bundle that best works for you from as low as 10 Ghana cedis weekly for unlimited access to all publications. Graphic, truth and accuracy every day. Information is a great source of power, adding to your options, knowing that quality and standard remains intact and our content, which is accepted as truth and accuracy every day, is accessible on the go. Access your favorite daily graphic and our weeklies The Mirror, Graphic Business, Graphic Showbiz, Junior Graphic, and Graphic Sports on Graphic News Plus app. It's the digital replicas of our work. Download Graphic News Plus app on the Google Play Store, Apple App Store, and available on www.graphicnewsplus.com as you remain abreast of and keep pace with on-the-minute news updates on the go. Home sweet home. Welcome family and friends. Choose the bundle that best works for you from as low as 10 Ghana cedis weekly for unlimited access to all publications. Graphic, truth and accuracy every day. Information is a great source of power, adding to your options, knowing that quality and standard remains intact and our content, which is accepted as truth and accuracy every day, is accessible on the go. Access your favorite daily graphic and our weeklies The Mirror, Graphic Business, Graphic Showbiz, Junior Graphic, and Graphic Sports on Graphic News Plus app. It's the digital replicas of our work. Download Graphic News Plus app on the Google Play Store, Apple App Store, and available on www.graphicnewsplus.com as you remain abreast of and keep pace with on-the-minute news updates on the go. Home sweet home. Welcome family and friends. Choose the bundle that best works for you from as low as 10 Ghana cedis weekly for unlimited access to all publications. Graphic, truth and accuracy every day. Information is a great source of power, adding to your options, knowing that quality and standard remains intact and our content, which is accepted as truth and accuracy every day, is accessible on the go. Access your favorite daily graphic and our weeklies The Mirror, Graphic Business, Graphic Showbiz, Junior Graphic, and Graphic Sports on Graphic News Plus app. It's the digital replicas of our work. Download Graphic News Plus app on the Google Play Store, Apple App Store, and available on www.graphicnewsplus.com as you remain abreast of and keep pace with on-the-minute news updates on the go. Home sweet home. Welcome family and friends. Choose the bundle that best works for you from as low as 10 Ghana cedis weekly for unlimited access to all publications. Graphic, truth and accuracy every day. Information is a great source of power, adding to your options, knowing that quality and standard remains intact and our content, which is accepted as truth and accuracy every day, is accessible on the go. Access your favorite daily graphic and our weeklies The Mirror, Graphic Business, Graphic Showbiz, Junior Graphic, and Graphic Sports on Graphic News Plus app. It's the digital replicas of our work. Download Graphic News Plus app on the Google Play Store, Apple App Store, and available on www.graphicnewsplus.com as you remain abreast of and keep pace with on-the-minute news updates on the go. Home sweet home. Welcome family and friends. Choose the bundle that best works for you from as low as 10 Ghana cedis weekly for unlimited access to all publications. Graphic, truth and accuracy every day. Information is a great source of power, adding to your options, knowing that quality and standard remains intact, and our content, which is accepted as truth and accuracy every day, is accessible on the go. Access your favorite daily graphic and our weeklies The Mirror, Graphic Business, Graphic Showbiz, Junior Graphic, and Graphic Sports on Graphic News Plus app. It's the digital replicas of our work. Download Graphic News Plus app on the Google Play Store, Apple App Store, and available on www.graphicnewsplus.com as you remain abreast of and keep pace with on-the-minute news updates on the go. Home sweet home. Welcome family and friends. Choose the bundle that best works for you from as low as 10 Ghana cedis weekly for unlimited access to all publications. Graphic, truth and accuracy every day. Information is a great source of power, adding to your options, knowing that quality and standard remains intact, and our content, which is accepted as truth and accuracy every day, is accessible on the go. Access your favorite daily graphic and our weeklies The Mirror, Graphic Business, Graphic Showbiz, Junior Graphic, and Graphic Sports on
There were limitations placed by the Constitution on the exercise of the powers of the person presiding. And so these constitutional limitations were supposed to constrain Parliament from proceeding any further with the bill. But that was not the case. The bill proceeded. And
Council, can you explain what the limitation you are talking about is, please?
My lady, respectfully, the limitation is simply that Parliament shall not proceed. If a bill is not introduced by the President, then if a private member introduces the bill, then there should be prima facie an analysis of the bill to see if it imposes a financial implication on the public purse. If it does, then Parliament cannot proceed. That is the meaning we place on Article 108.
Your summary seems to skip a few salient points. Can you quote what the Constitution says in that regard?
It says that Parliament shall not proceed if the bill imposes a charge on the consolidated fund or other public funds of Ghana. That is 108A Roman number 2. That is what it says.
You read more than that, Council.
Yes, but
can you give a faithful rendition of what the Constitution says instead of just picking and choosing?
So Roman, to go back to your submissions, A says that Parliament, 108 says Parliament shall not, unless the bill is introduced by the President, and A says that proceed upon a bill, including an amendment to a bill, if in the opinion of the person presiding, it makes provision for Roman 1, the imposition of taxation or the alteration of taxation, otherwise than by reduction. What does that mean? I believe that's the question being asked.
Yes, we are not grounding our case on AI, but on number 2 and 3.
And 2 reads?
2 reads, the position of a charge on the consolidated fund or other public funds of Ghana, or the alteration of any such charge otherwise than by reduction. And
does the 2 stand by itself, or it is controlled by the part that was read by a ladyship?
Yes, my lady, it is controlled by the preceding paragraphs.
Give a faithful rendition of it so we follow your argument.
In my own words, or I should read from the Constitution?
Just to assist, Parliament shall not, unless the bill is introduced or the motion is introduced by on behalf of the President, proceed upon a bill including an amendment to a bill that, in the opinion of the person presiding, makes provision for any of the following, and you say you are grounded on Roman 2. Yes. The imposition of a charge on the consolidated fund or other public funds of Ghana, or the alteration of any such charge, otherwise than by reduction. So,
and then 3.
What does this mean?
Lady, what it means is that if a bill is introduced in Parliament, which is not by the President, there must be a fiscal impact analysis. So the fiscal impact analysis
must accompany the bill. And then based on that fiscal impact analysis, the person presiding looks at it and say, if the bill says we are going to arrest and detain people, even the pre-trial processes will incur some cost. And so, if that analysis is done, and it accompanies the bill, then the person presiding is in a position to say that this bill cannot proceed. It's being coming from a private member, but not the president. Because the essence of the law is that Parliament checks the public purse, but it does not spend the public purse. It does not tell the executive how to spend the money of the country. It is the executive that decides to spend, and Parliament acts as a check. And so this provision is acting as a check or a limitation on members of Parliament that want to rule the country from Parliament. It is the executive that rules, not Parliament. And so the essence of the bill is saying that if you want to introduce a bill, that is fair enough. But make sure that that bill does not impose a charge on the public purse, because the executive that determines how the money of the country is spent. And so if a fiscal impact analysis is placed before Parliament, the person presiding does not make an opinion arbitrarily, but in a fair and candid manner to say that I am guided by this, it imposes a charge on the consolidated fund, and therefore we shall not proceed with this bill.
So how does what you have read tie in with the specific facts of this case? That is what I think we...
Yes, my lord, the specific facts of this case is that when the bill was first introduced, there was no fiscal impact analysis. When it was first read, it was referred to the Constitutional, Legal, and Parliamentary Affairs of Parliament. So the Constitutional and Legal Committee sought the opinion of the second respondent. And the second respondent, in a letter...
the Attorney General.
The Attorney General, my lords. And in a letter dated the 19th of October 2022, with reference number LI 7/2021, the Attorney General, specifically on page 5 of that report, clearly stated that it is observed that the bill...
I don't like the language. Did you say observed or absurd?
Lady, I'll read it for you.
Read. It's exhibit.
Lady, this is exhibit A1.
Yes.
Lady, and it is paragraph 1, 2, 3, 4, 5, 6.
Paragraph 6.
Paragraph 6.
On page?
On page 5. And the advice reads, it is observed that the bill is not accompanied by a fiscal impact analysis required by Section 101 of Act 921. The stipulation in Section 101 of Act 921 is rendered more imperative by the character of the bill as a private member's bill. So this is the advice as attached to Exhibit A1. Yes, my lord.
The observation is the advice?
It's an observation, but it goes on to say, it analyzes the bill one by one, and then even before this paragraph, the advice says, that is paragraph, starting from paragraph 3. It says, thus, the passage of the bill is subject to subparagraph 3 of paragraph A of Article 108 of the Constitution. A determination of the satisfaction of the conditions in Article 108 ought to be made objectively by the person presiding over proceedings in Parliament on the basis of analysis properly conducted by proponents of any bill in question. And it goes on, it is for this reason that Section 101 of the Public Financial Management Act 2016 stipulates that any legislation to be laid before Parliament or proposal submitted for the approval of Parliament shall be accompanied by a fiscal impact analysis, stating the estimated effect on revenue and expenditure for the financial year in which the legislation or proposal is expected to come into effect. Lords, what we are saying is that despite this advice, the bill proceeded. in Parliament, despite also the pendency of this application or this writ, which was issued on 1st June 2023 before you, Lord, the bill proceeded, and at various times there were statements to the effect that Parliament will pass the bill willy-nilly, despite the advice and despite the pendency of this suit. My lords, we are aware, I'll turn to our statement of case. As I've noted earlier, we rely on our statement of case, which is an 80 paragraph statement of case. But we also wish to make a viva voce explanation of the points we have raised. And my lords, I want to tie it in with the response by the first respondent, because we are going to argue that the conditions for the grant of an injunction to restrain the Impunity Act is rife, it is present, and we'll tie in it with the response or the affidavit in opposition by the first respondent. My lords, the affidavit in opposition filed by the first respondent on 20th May 2024, pursuant to the order of this court on May 8th, 2024, is not accompanied by a statement of case. A statement of case was not filed, but the first defendant respondent attacks our application, and we sum their attack on our application on 5 major grounds. First, that the present application for injunction is materially the same as the application which was dismissed by the court on 19 July 2023. It states that in paragraphs 9 to 18. Secondly, they say the President has expressed an unwillingness to assent to the bill, paragraphs 19 to 22. They also talk about the fact that the grounds for the...
To 9 to 18.
Yes, maybe.
I believe you first referred to the essence of paragraphs 9 to 18.
Yes.
Can you go back to that?
Yes. The point we are making is that their claim, or in sum, what they are saying in paragraphs 9 to 18 is that the present application for injunction is materially the same as the application which was dismissed by this court on 19 July 2023. Then, in paragraphs 19 to 22, paragraphs 19 to 22, the essence of what they are saying is that the President has expressed an unwillingness to assent to the bill. That is paragraphs 19 to 22. Then they go on to say in paragraphs 29 to 30 that the grounds for grant for an order of interlocutory injunction have not been proven by the applicant. And then, finally, in paragraphs 23 to 27, they say that the report of the committee indicates that the AG's concerns have been addressed. 23, my lady, to 27, they allege that the report of the committee indicates that the AG's concerns have been addressed. And one final point, they also claim that the fiscal impact analysis has been conducted. Paragraph 28. Lord, it is this that we now turn our attention to respond to and then tie it in with our own legal submissions. Yes. My lords, the first point that the present application is materially the same as the previous one is inaccurate. At the time of the hearing of the first application for injunction in July 2023, the bill was still being considered in Parliament, and indeed, we have attached Exhibit A2, which suggests that the Speaker had directed that the bill be considered either on the 23rd or the 27th of July, despite the pendency of the writ and the application for injunction. Lord, at the time of filing this present application, the work of Parliament in terms of considering the bill is completed, and Parliament has attempted to transmit the bill to the President. And my Lord, our point is that there is a changed circumstance, a material change circumstance, in fact and in law, and the fact that a previous application has been dismissed does not prevent us from bringing another one if the material facts have changed. And indeed, we are fortified by the case of Ajikum versus Asekum Engineering and Construction Limited. Ajikum versus Asekum Engineering and Construction Limited. Lord, is a 1989-1992 Ghana Law Report at page 650. Lord, and clearly this court made it clear that the fact that an application has been dismissed earlier doesn't mean that when the change, there are circumstances that change, another application cannot be brought before the court. Lord, if I may read what this court said in that case at page 650, you see,
Page
650. Lord, the court said.
Did you say 650?
650, my lady. It reads.
No, the citation I got from you.
Yes, my lady.
Is 2GLR at 250 or 650?
650.
Sorry.
650. Lord, this is what this court said. He said, it has been known, indeed, it's on page 5 of 15 of our statement of case. It says, it has been known for rulings in interim injunctions to be changed in the course of the same case when the change is warranted by changed circumstances or on the occurrence of new matters. For example, a refusal to grant an application at one stage may, on repeat application, specifying changed circumstances or new matters, especially as to balance of hardship, be reversed and application granted, unquote. Lady, we move on to the second point canvassed by the first respondent. And it is that the President has expressed an unwillingness to assent to the bill. My Lords, nothing is further away from the truth than this. The statement of the Secretary to the President, as captured in Exhibit 2 of the first respondent's affidavit in opposition, is to the effect that the President will not take any steps in respect of the bill until the injunction application is determined, so as not to undermine the authority of this court and prejudice the application. Lords, the relevant portion of the statement is as follows, and it's paragraph 3, line 7 of the letter signed by the Secretary to the President. And it reads, indeed, it is settled law that during the pendency of an interlocutory injunction application, the status quo ante ought to be preserved and no action should be taken that will result in prejudicing the injunctive relief sought and undermining the authority of the court. Lord, this is what it says. The President or the Secretary to the President never said the President has expressed an unwillingness to assent to the bill. So that claim is factually inaccurate. Lord, Thirdly, the first respondent argues that the grounds for the grant of an interlocutory injunction has not been proven by the applicant. Lord, it is our contention that we have proven all the elements for the grant of an injunction in paragraphs 33 to 75, paragraphs 33 to 75 in our statement of case in support of the injunction application.
Which elements are?
Which elements are, my Lord, relying on the case of Welfare Kwaku, is that whether there is a serious question to be tried, that is first. 2, whether the applicant will suffer irreparable damage which cannot be remedied by the award of damages. And then 3, whether the balance of convenience is in favor of granting him or her the interlocutory injunction. My Lord, also in the case of Michael Ankuma Nimfa versus Jachikweshin and others, the court reiterated these conditions for the grant of injunction. Lord, we claim, or we assert, through our statement of case in paragraph 33 to 75, that one, the applicant has a legal right. The applicant has a legal right which stems from Article 2.1 of the 1992 Constitution that must be protected. The applicant, as a citizen of Ghana, has a right to commence this present action. And indeed, Article 3.4 of the Constitution also imposes an obligation on all citizens, including the applicant, to defend the Constitution. Lord, again, the case of the applicant is not frivolous. The case of the applicant is not frivolous. The applicant is alleging an egregious breach of Article 108 of the 1992 Constitution, which is a matter of public interest that affects all Ghanaians. An alleged violation of the Constitution by the officers sworn to protect it. It's not a frivolous matter, but a matter of utmost importance to protect the sanctity of the Constitution, our democracy, and the respect for rule of law. Lord, again, the respondents will not suffer any hardship if the injunction application is granted. As any inconvenience that they may suffer is not personal. Lord, we rely on the case of Ghana Independent Broadcasters Association versus the Attorney General and the National Media Commission. And my lords, it's reported as 2017-2021 Supreme Court of Ghana Law Report 498. My lords, it's our contention that the respondents will not suffer any hardship if the injunction application is granted. But on the other hand, if this application is refused, the applicant and every citizen of Ghana will continue to endure a flagrant and blatant violation of the 1992 Constitution, and the court cannot shut its eyes to such violation. But again, we contend that irreparable harm will be caused to all Ghanaians by the refusal of this injunction application. Assuming the bill becomes law. My Lord, indeed, even on 28 February 2024, when the bill was passed, people thought it had become law, and some members of a certain community suffered violence. My Lord, this is a bill that attempts to take away rights of citizens. This is a bill that also imposes a charge on the public purse. My Lord, even the pre-trial matters, if this occurs, my Lord, the dignity of the Constitution, as well as the dignity of the individuals who may suffer arrest and detention, can never be fully compensated by any damages, the award of damages.
think you're forgetting that what you are seeking to injunct is the transmission to the president. The bill will not become law unless the president signs. So that's what you should be addressing. Why should this court interfere with the proceedings between Parliament and the presidency before the bill becomes law?
Lord, we think that this court must intervene because this is a constitutional democracy. We have moved from an era of obey before complain to an era of justification. If any public institution, any public official has to do anything, the person must justify their actions within the Constitution. Now, the Constitution says, you shall not proceed with a bill that is introduced by private members. We have endured this for a while. This is a flagrant violation of Article 108 of the Constitution. We have endured this for a while, even though this writ has been pending in this court since 1st June 2023. Because we think that having gone on to consider the bill, finalize it, even in spite of the advice, even by the second respondent, it is about time that someone steps in. And it is this court that can do that job, to step in, to stop the transmission of the bill until the final determination of this matter. Lord, we have already argued that the matters raised.
Counsel, why can't you trust the president to exercise his powers under the Constitution?
Well, that's a very good thing to say. And we agree with that the president will assert his rights under the Constitution. But once there have been a violation of the Constitution, and clearly the wording of Article 108 says that somebody...
Isn't that part of the duties of a president?
But Lord, it has not moved to the duty of the president yet. We are still in Parliament. And we are saying that once a violation has occurred, and the Constitution says somebody should raise their hand, and the plaintiff applicant has raised their hand.
When Parliament has passed a bill,
yes,
has it not finished its work? Doesn't it move to the next stage where the Constitution prescribes what must be done?
My lady, the bill shouldn't have reached this stage in the first place, but it has reached this stage. Assuming it goes to the president, and the president refuses to assent, it comes last with Parliament. And in that case, Parliament can go ahead to pass it. We have the requisite numbers.
But the Constitution has laid down a procedure to be followed. Why can't you trust the process to follow through, and if the results are not to your taste, then you can come and complain?
Yes, my Lord, that's also a valid argument to make. But this is the only, I'll venture to say, the only article in this Constitution, Article 108, that says that a bill can be challenged even before it becomes law. Article 108, by the wording, shows clearly that this is the only one. And this is the first time this court is hearing this matter. And we think that a hand has been raised, and the court should listen to the hand that has been raised. Because if all things being equal, if the right processes, this is not a mundane parliamentary procedure that has been flawed. This is a constitutional violation, because the Constitution says don't proceed, and you have proceeded. And so even the cost associated with considering this bill.
Counsel,
yes,
it is a very important matter you are addressing. That's why I want you not to overlook certain things. Yes, 108 talks about some limitations. It also talks about, in the opinion of the person presiding. Why don't you address those matters so that they show clearly what should have been done and wasn't done? Sometimes I've been trying to listen and follow and trying to draw your attention to the fact that don't skip important aspects of the argument.
The professor is speaking.
Yes, my lady. My Prof, Lady Justice.
The professor in here is itching.
Prof, Lady Justice. Yes. My lords, The point we are making is this, that Section 100(1) of Act 921, as well as Article 108, a combined reading of the Constitution and the legislation, clearly suggests that at the time a private member introduces a bill, there must be a financial impact analysis. And a financial impact analysis should show that this is the cost the state is going to bear. If there is no cost associated with the bill, then it goes through, and nobody has a problem. But if there is a cost associated with the bill, that is where the bill must stop.
Now, what will be the cost associated with this bill?
Lady, clearly...
Where will the cost come from?
The cost will be when the pre-trial matters are triggered. For instance, an arrest. It will involve the state's coercive forces to arrest people. A lot of detention. People will be kept in detention, they have to be fed. If they are sick, they have to go to the hospital. My lords, the bill even imposes a duty on all citizens, the judiciary, the legislature. That requires some resources to actualize this. Even when people are supposed to undergo so-called conversion therapy, they all require resources of the state to be spent. I mean, Lord, we are all painfully aware of the conditions in our prisons. The prisons are overcrowded. People don't have 3 square meals in a day. They are not able to attend clinic and all that. And we are going to add more people. And it even moves beyond them. It's not even going to affect academia. I'm an academic, I teach, and from the wording of the bill, I cannot go to class and talk about human rights and discuss the rights of LGBT because I could be arrested as well.
Counsel, I think that is the substantive case. At this stage, the question my sister is trying to ask you is, why should we injunct an institution? You know, the gravamen of your case is based on Article 108, yeah. And then 100, Section 100 of Act 921. All right, that is the gravamen of your case. We haven't gotten there yet. So the question is, why should we injunct an institution which is an arm of government that we've given a mandate to do certain things? That's yeah. So at this stage, why should we injunct them? I think that's what
Council. So we have 3 arms of government working here. All are required to be independent, to be able to take their decisions independently. So Parliament has taken its decision. You have a problem with that decision. You've come to the Supreme Court, which is your right under Article 2.1. You have clearly outlined that. But you are asking the Supreme Court to stop a communication between Parliament and the executive. And if you recall, my sister to my left asked, why can't the executive be allowed to take its own decisions on this matter? Yeah. And if they take the wrong decisions that violate the Constitution as you allege, then it will be the duty of the Supreme Court to correct it.
Lady, our simple answer is that the violation has already occurred. The violation of the Constitution has already occurred. And some may choose to wait, but the plaintiff decided that we cannot wait to endure any further breaches of the law.
So we don't have any problem with you on that.
Yeah.
You know, you are here to challenge whether the bill, so far as you are concerned, you know, went through the proper processes. And your trump card is Article 108. And then Section 100 of Act 9.2. We are here. That is the main, you know, a course of action. That's why you are before us. But in the interim, you want us to injunct, you know, an arm of government, and that's where we have a little bit of a problem. We
want you to address us on that specific question. In what you see, you make the point that there's been a violation of the Constitution. That's your That's your submission. Are you presenting that whenever there's a violation of the Constitution, the jurisdiction of the Supreme Court is so invoked that the Supreme Court cannot exercise its discretion to restrain itself to see whether that violation will continue or it will not continue? Don't forget that there has not been a determination of whether there's been a violation or not. Yes. That's your position.
Yes.
Or you think you've addressed us enough?
Milady, I think I've done my bit, but I still get the point you're making. And the point, maybe I'll add to it to see if I meet your expectations. The point is that the Constitution gave birth to Parliament. It gives it powers. It says do A, B, C, D. Don't do E, F, G. And then they overstep their bound to do what the Constitution says don't do. Now we are saying that if what they have been asked by the Constitution and a constitutional supremacy that don't do, if they do, the impugned act, if the bill becomes law, assuming all things being equal, it is signed, it becomes law, the damage or the harm, the indignity that the Constitution will suffer, the indignity that the plaintiff and citizens of Ghana will suffer, can never be compensated.
This is on the irreparable damage.
Irreparable damage. So the damage that will be caused is so irreparable. But meanwhile, the bill has been on ice since 28th February. A few more weeks, a few more months, and they will not suffer any damage personally. Indeed, there are other bills, other laws that have been proposed that give rights to citizens. Affirmative action bills, spousal rights bills.
Very well, very well. I think your point is taken. Since you haven't added to what you said clearly, we should just take what you have given. Do you have any more points, or should we move on to another?
Well, maybe I'll add that the remedy, if there's a violation of the Constitution, does not lie with the President, but it lies with this court. And so therefore, we shouldn't wait for the President to remedy a violation. It is for the courts to do so. And so that is the small point I will add to that. And my lords, finally, in addressing Lords, finally, we want to...
You need to be rounding up.
Yes, my lords. Lords, finally, the first respondent purports to have attached...
You mean Parliament?
Parliament, yes. Purports to have attached a fiscal impact analysis which was conducted in respect of the bill to the supplementary affidavit. Yes, as exhibit... my Lord, will refer you to Exhibit 4 of their supplementary affidavit, which was filed. Okay, my Lords, we'll first go to the affidavit in opposition filed by the first respondent on 20th May 2024. Lord, Exhibit 4. It's Exhibit 4. Lord, they claim to have attached the fiscal impact analysis that was conducted in respect of this bill. But my Lord, if we look at the exhibit, it is rather an extract of the Public Financial Management Regulations 2019, LI 2378. My lords will also recall that the first respondent's supplementary affidavit filed without leave of this court on 30th April 2024. They also purported to have attached a fiscal impact analysis. Again, they did not attach it, but rather attached the same exhibit in this one.
In the extract from the law.
The law, the extract from the law.
The bare provisions of the law.
Yes, the bare provisions of the law, without more, my lady. Lord, it's our contention that clearly the fiscal impact analysis has not been conducted. Since on all these two occasions, they purported to have attached the fiscal impact analysis, but it turns out that they have not done so. My Lord, the second and most important point in relation to this is that this averment that the fiscal impact analysis has been conducted is inconsistent with all the previous processes filed before this court by all parties, including the first respondents' amended statement of case filed on 14th March 2024. Their claim that they have done the fiscal impact analysis is inconsistent. It's inconsistent with their amended statement of case filed on 14th March 2024. Lords, I'll respectfully refer you to paragraph 20, Roman numeral 2.
Please read it.
Yes, it's under the heading Admitted Facts. And it says, the first defendant agrees that the bill was presented to Parliament on 29 June 2021 as a private member's bill. 2, the bill was not accompanied by a fiscal impact analysis nor a document detailing the financial implications in respect of public funds as a result of the bill at the time it was first laid in Parliament. 3, first defendant nevertheless referred the bill to the committee for deliberations without an opinion as to whether or not the bill imposes a financial burden on the state. 4, chairman of the committee wrote a letter to the second defendant.
You refer to an affidavit of 14th March.
That is, yes, we first refer to an affidavit of 30th April.
No.
What I'm reading now,
yes,
it's 14th March 2024.
14th March?
It's the first defendant's amended statement of case.
Oh, you said affidavit?
I'm so sorry.
But I thought initially you complained that he had not filed any statement of case.
Yes.
When you started your submission.
Lord, this is for the substantive case, okay, not the injunction application. Yes.
Looking for an affidavit.
Lord, it's page 5 of 43.
We have an affidavit filed on 22nd March.
You are referring to a statement of case filed in support of a substantive suit. Isn't that the case?
Yes, my Lord, we refer to 3 documents. So
what you are reading?
What I'm reading now,
yes,
is the first defendant's amended statement of case, filed on 14th March 2024 at 12:10 p.m.
You refer to an affidavit.
Lord, the affidavit I refer to is the current one, which is opposing our application for injunction. Good.
The difficulty we are having is that the record of the substantive matter is not before us. What is before us is the record of the application. And so we don't have the affidavit you are referring to.
Yeah.
The statement of case you are referring to.
Very good.
You can round up.
Yes.
You're taking up quite a bit of time.
Lady, so it is our prayer that our injunction application respectfully be granted, and we pray accordingly.
So sorry. What I was thinking is that we listen to both sides, since they are both attacking you. The application is against you. Yes, so we listen to the Attorney General as well.
Most grateful.
And then you are the principal respondent. So you respond there. Thank you very much.
Leadership, I'm grateful. The court would note that we have, in a very unconventional manner, not explicitly indicated whether we oppose to the application or not. That is very much consistent with my philosophy that in matters of this nature, in constitutional actions, the court's duty is to settle questions, to settle important questions of law that arise, and not necessarily decide cases. The distinction has to be made between the court's exercise in settling a question rather than deciding the case. And this is one important matter that, with all respect, I submit that the court ought to settle very fundamental questions that arise in the plaintiff's action. And therefore, the interest of the Attorney General, with all respect, is not necessarily to state a position in favor of one party or not. Because the issues that arise in this matter, for me, go beyond the interests of a specific party and rather impinge on how the provisions of the Constitution, insofar as the exercise of legislative power by Parliament with regards to financial matters, ought to be done. Especially, indeed, the application before you is an application for interlocutory injunction. And I recognize that the plaintiff's main basis are three. The plaintiff's main basis for the instant action are three. Firstly, the plaintiff's action seeks to question the power of the Speaker in admitting for consideration by Parliament the bill that has been described as the Human and Sexual Family Values Bill of 2024, a copy of which has been annexed to the plaintiff's application. Secondly, the plaintiff raises issues which allege violations of some provisions of the Fundamental Human Rights Chapter of the Constitution, Chapter 25. Then also the plaintiff...
Chapter 5.
Chapter 5, I'm sorry. Chapter 5, I'm sorry. Chapter 5. Then also the plaintiff questions... I think that is it. It's only which is carried out. It's a third basis. So those are the two main bases. And my lords, for me, the main basis for the grant of an interlocutory injunction in the constitutional case is whether substantial questions of law have been raised. The court may also proceed to consider the justness or convenience in granting an interlocutory injunction. Indeed, I've examined the court's exercise in this regard since 1996, and I note that in certain constitutional cases, a few of them, it must be stated, a few of them, injunctions are granted. I refer to a quam against PNM number 1, reported in 1996-97 Supreme Court of Ghana Law Report, at page 117, in which the court granted an injunction in a constitutional action. I will, in the course of the submissions, also examine other decisions of the court in which injunctions or injunction applications were denied. So the court would note that we have set out 3 main issues that have to be considered by the court in adjudicating on the plaintiff's application. The first issue, with all respect, is whether or not the passage of the Human Sexual Rights and Family Values Bill 2024 by Parliament on 28 February 2024, prima facie, constitutes an act under Article 2, Clause 1, Paragraph B of the Constitution, so as to vest in the plaintiff, a citizen of Ghana, a cause of action. The second issue is whether or not prima facie a contravention of Article 108 of the Constitution is disclosed in the processes leading to the passage of the Human and Sexual Rights and Family Values Bill 2024 passed by Parliament. And then the second one is whether or not prima facie a contravention of Article 108 of the Constitution is disclosed in the processes leading to the passage of the Human Sexual Rights and Family Values Bill 2024 passed by Parliament. The third issue is whether or not the plaintiff's action prima facie discloses real allegations of violations of the provisions of the Constitution of fundamental human rights. Especially, I would seek leave of the court to address the second issue, which I indicated as having been raised by us, because I consider that issue very fundamental. Right?
Indeed, the plaintiff applicants dwelt extensively on that.
Yes, precisely. But that issue centers around an allegation of a contravention of Article 108 of the Constitution. Respectfully, 108 of the Constitution, although has been read by the plaintiff, but if I may, just for the avoidance of doubt and for the sake of emphasis, could say, I leave of the court, I proceed. Parliament shall not, unless the bill is introduced or the motion is introduced by or on behalf of the President, A, proceed upon a bill, including an amendment to a bill, that, in the opinion of the person presiding, makes provision for any of the following: Roman numeral I or 1, the imposition of taxation or the alteration of taxation, otherwise than by reduction, or Roman 2, the imposition of a charge on the consolidated fund or other public funds of Ghana, or the alteration of any such charge otherwise than by reduction, or Roman 3, the payment, issue or withdrawal from the consolidated fund or other public funds of Ghana of any monies not charged on the consolidated fund, or any increase in the amount of that payment, issue or withdrawal. Indeed, I would like to rest here because those 3 for me are the most important for the purpose of this exercise. And the points I note from Article 108 is that, first, the conditional phrase in paragraph A. First, the conditional phrase in the commencement of the provision itself. Parliament shall not, unless the bill is introduced. The conditional phrase indicated there actually restricts the power of Parliament to exercise its legislative authority vested in it by Article 93, Clause 1 of the Constitution. Article 93, Clause 2 of the Constitution. And I say that the conditional phrase restricts it because, indeed, the provision itself proceeds to set out the specific matters that Parliament is prohibited from considering insofar as those matters come within the premises of Article 108. And those are: 1, a bill that, in the opinion of the person presiding, makes provisions for 1, the imposition of taxation or alteration of taxation, otherwise than by reduction. So insofar as there's any bill which has the effect of imposing taxation or reducing taxation or altering, imposing taxation or altering taxation other than by reduction, then it shall come under Article 108. Secondly, most importantly for this exercise, the imposition of a charge on the constituted fund or other public funds of Ghana, or the alteration of any such charge otherwise than by reduction. Indeed, the Constitution does not define charge. But my lady, clearly, the ordinary meaning of a charge on the constituted fund is a burden being placed on the constituted fund. So far as there's a burden being placed on the public purse of Ghana, that's the constituted fund, then clearly such a matter must come within the specific details of Article 108. Then Roman 3 of paragraph A of Article 108 says the payment, issue, or withdrawal from the constituted fund or other public funds of Ghana of any money is not charged on the constituted fund, or any increase in the amount of that payment, issue, or withdrawal. Again, insofar as there's a payment, issue, or withdrawal, or a bill which has the consequence of ensuring a payment, issue, or withdrawal from the bill, clearly there must be, from the fund, constituted fund, clearly there must be recourse to Article 108 of the Constitution. Indeed, yes.
The 108A1 that you read, the one about otherwise than by reduction.
Right.
I'm trying to think of a situation where a bill could reduce taxes without affecting the income or revenue of the state. So I'm looking at how one can be achieved, Roman 1 can be achieved, for example, which does not violate Roman 2.
True. Yes. I think that's a very good observation, respectfully. And I would say that that is actually the basis for a holistic interpretation of the Constitution. So in construing the Constitution, you do not indeed look at it narrowly. And if indeed the court were to adopt such a constructive approach to interpretation of statutes, which is by looking at the statute as a whole, I would say, with all respect, that indeed, having regard to or by virtue of the combined effect of Roman 1 and 2, even such a bill must be caught within the demands of Article 108. That is a bill which is effectively reduces taxation. An argument can be made that indeed, to the extent that such a bill results in the reduction of the public purse, it must come within the premise of Article 108. So indeed, I agree with the court of the observation of my lady. My lady, I make the further point that indeed, Article 108 seeks to place the prerogative of the determination as to whether a matter comes within the premises of Article 108 on the Speaker, the person presiding in Parliament. It may not necessarily be the Speaker of Parliament. It may even be another member of Parliament who has been mandated to preside over proceedings. Yes, but that is where...
What does on the person presiding
mean?
What would that mean in law?
In law. But it means a person, it means first and foremost the Speaker of Parliament, or in his absence, a Deputy Speaker, or in the absence of a Deputy Speaker, a person who has been mandated to preside over proceedings of Parliament. Because indeed, if the court were to look at Article...
Yes, and yes. Also, in order not to spend much time on that, what does, in the opinion, also mean in law? Yes. What would that require?
Right. So, maybe 2 points. First and foremost, the determination. In the opinion of the person presiding means as per the determination of the person presiding. But secondly, and more importantly, that determination must be subject to the Constitution. Because finally, the exercise of any discretion whatsoever under the Constitution is not unconstrained.
It's not?
Unconstrained. It's not unconstrained. It means it is constrained. And it is constrained by the Constitution. And if there's a dispute, it is subject to the determination of the Supreme Court. The Supreme Court's jurisdiction can be properly invoked to determine whether a person's discretion conferred by the Constitution has been properly exercised in accordance with the dictates or the demands of the provision of the Constitution by which the person is supposed to go by which the person is supposed to go. Now, my lady, indeed, this proposition is not novel. It is one that has been amply established by the court in numerous authorities. I can refer with all respect to J.H. Windsor against the Attorney General, reported in the Supreme Court of Ghana law report.
You mean the proposition regarding discretion?
No, proposition regarding even, specifically even relation to Parliament. Mm-hmm. That even Parliament, the conduct of parliamentary proceedings and powers imposed on Parliament.
Are all subject to the Supreme Court?
Subject to the Constitution itself. So J.H. Windsor and Attorney General established that reported 1996, 97, Supreme Court of Ghana law report. Mm-hmm. At page 320. It had earlier on been firmly established in before an Attorney General, 1918 Supreme Court of Ghana report. Especially, quite recently, even the Abu Ramadan line of cases, the court asserted that even in relation to the Electoral Commission, which has absolute independence in the conduct of elections and the making of regulations, even the regulations that the Electoral Commission comes up with, subject to the determination by the Supreme Court as to whether it is compliant with the Constitution or not. So already the firm point for the established is that the opinion of the person presiding in Parliament does not confer on that person an unconstrained discretion. And
in order to focus, I would like to remind you of the submission by counsel for appellant that, applicant, that in his view, there's been a contravention of Article 108.
Right.
And that very occurrence provokes the jurisdiction of this court. And that very occurrence must provoke the invocation, the issue of an injunction.
Right.
If you could address that.
Yes, I'll quickly address that. But if I may quickly also refer to a point that we raised in a civil case that we filed, which is Sky matter. But in this matter, I didn't file a civil case because the court had not ordered for us to file so. But that point is that indeed, if the court were to look at all the constitutions this country has had since independence, the court would note that a provision in the nature of Article 108 has been present in every constitution, apart from the 19th state constitution, which of course made the president a lifetime president. So from the 1957, even the independence constitution, and the provision was replicated, and that was in Article 41 of the 1957 constitution. And specifically, if I may quickly read, Clause 2 of Article 41 says, except with the recommendation Clause 2 of Article 41 of the 1957 Constitution, that except with the recommendation or consent of the Governor General signified thereto, the Assembly shall not proceed upon any bill, motion, or petition which the opinion of the Speaker or a member presiding will dispose of or charge the constituted fund or other public funds of Ghana, or revoke or alter any disposition thereof, and thereon, or impose, alter, or repeal any rate, tax, or duty. The same. Especially in the 1969 Constitution, indeed, provisions of the nature as the 1992 Constitution were first introduced. In 1969, it was in Article 85 of the 1969 Constitution, and it stipulates as follows. Permission if I may read. It said the National Assembly shall not, unless the bill is introduced, or the motion is introduced by a minister, A, proceed upon any bill, including any amendment to a bill, that in the opinion of the person presiding makes provision for any of the following. That is to say, that it lists all the factors there, the imposition of taxation or the alteration of taxation otherwise than by reduction, and then similar provisions also there. Same is also found in the 1979 Constitution. But the point I seek to make out of this,
just to provide some assistance, in the 79 Constitution, the parallel provision is Article.
It is Article. It's Article 90 of the 1979 Constitution. Article 90.
Yes.
But the point I seek to make from all of this is that, indeed, these financial provisions are so important to the nation that the Constitution has deliberately sought to insert them. And the Constitution, in its deliberate framework, once again, seeks to centralize the management of the public purse. And for that matter, the imposition of any charge on the public purse or a withdrawal from the public purse must be done strictly pursuant to the initiative of the executive. But I made this proposition not because I'm a member of the executive, but because by virtue of Article 88 of the Constitution, I'm the principal legal advisor to the government, and as the courts have held from time immemorial, the Attorney General is a protector of the public interest. And therefore, it matters that border on the public interest, the public purse and all, I take a keen interest in. Especially, I say that, indeed, the court, in my respectful view, the bill as presently constituted, and I've taken time to set it out in the other matter, it is the same bill, for that matter, I'll quickly refer to the particular provisions that I alluded to there. The bill, by virtue of certain provisions, really seek to impose a burden on the constituted fund. And it is not the position I took after the instant action was filed. Indeed, it is a position I expressed in my opinion to Parliament during its deliberative processes on the bill. I've attached a copy of my opinion to Parliament as Exhibit AG. And respectfully, I allude to clauses.
AG?
Yes.
AG, when...
Yes. I'm sorry, my lady, sorry.
When you were talking about the importance of the discretion and so on, and how the Constitution controlled it, I hoped you would go beyond it to show how it should be signified, right, for it to be ascertainable.
Right.
But
that the discretion is constrained.
You said discretion, so how is it to be signified?
How is it to be exercised?
Yes. But I think first and foremost is signified through the manner in which the particular provision has been formulated. Now, my lady, in respect of this particular case, the court will note that, as I indicated earlier on, that there is a specific prohibition on Parliament itself from proceeding And then also, there is also an indication of certain factors that will have to be considered by the person presiding. So the factors to circumscribe the exercise of that discretion are spelled out clearly in the provision itself. That is Article 108.
No, AG, I think that's what my lady was asking, if I'm not mistaken, is the opinion that has to be expressed by the person presiding. How is it expressed? Is it already so that it can be ascertainable?
Right.
So does the person say, I have read everything, and in my opinion, it goes into the Hansard, or as submitted by counsel for applicants, it should be signified or expressed by the accompaniment of the fiscal analysis. That was his submission. Or, in your opinion, there's another way?
I would say that those two factors are important, and perhaps I'll add the third one. But the first and foremost, there must be an ascertainable exercise of that discretion. That discretion should be ascertainable that it has been exercised. So there must be a specific determination. That is why I found it a little bit worrying, with all respect, that there seems to be an omission of a determination by the Speaker attached to the Speaker of Parliament's processes. Indeed, the court will know that traditionally I would have raised an objection even to the Speaker of Parliament being a proper party to this action. But I deliberately did not raise an objection because I felt that the matters are so important, such that the view of the Speaker of Parliament perhaps may not be consistent with that of the Attorney General, and for that matter, he ought to be a party. And I felt that if indeed that the Speaker of Parliament is made a party, has been allowed to be a party to this action, and the Speaker of Parliament then contends that he exercised his discretion and actually made a determination that the bill fell outside the premise of Article 108, there must be an exhibition of the exercise of that discretion. So in essence, there must be, if it were a court, there must be the ruling attached. In this case, there must be the proceedings or perhaps an extract from the Hansard of the proceedings by which the Speaker of Parliament made that determination. That is the first step. The second step is that the Speaker of Parliament, it being an exercise of discretion in the Constitution, would have been bound by Article 296 to rationalize why such a determination was made. There must be a reasoned ruling, a reasoned determination to assist not only the court but the entire nation as to why such a determination was made.
So, AG, you will not accept. Sorry.
Yes,
And
so you will not accept quote and unquote determination by conduct, that the fact that the person presiding allows it to proceed is an indication that the person's opinion is that it conforms to whatever.
No, but that would be very much unhelpful.
It will not be. I just wanted you to say something categorical.
Right. Yes, but it will not be helpful because then it denies an assessment as to the reasonableness or otherwise, or indeed even the propriety of the exercise of that discretion. Then also a third factor is that the Public Financial Management Act, as has been alluded to by the Attorney General, in fact, I stated it even in my opinion to Parliament, has sought to bolster Article 108 by requiring that any bill must be accompanied by financial analysis. Because indeed, again, Malaria, I say it bolsters because it reinforces the contention I'm making that there is a centralized process for management of public funds. And therefore, where there's any charge at all on the public funds, there must be a demonstration of how it affects the public funds or the extent to which it affects the public funds. And if there's also an allegation that the bill is no burden or no constraint on the public funds, there must be that analysis. And that is set out in the financial analysis required by the Public Financial Management Act.
Attorney General, what I am picking up from this morning's submissions and from the processes before us is that not only has the Constitution provided that there must be a determination in the opinion of the person presiding, but the Constitution has gone on through the statute to set out how to assist with how that determination ought to be made.
Precisely. Made. The fact is.
So I have understood you.
Yes, please. The fact is that's indeed, I'll quickly move on to why certain circumstances the courts do not really grant an injunction in a constitutional case. And the reasons are not far-fetched. Right.
You go on, Honorable Attorney General. If I understand what the position you are taking, your position clearly is that this bill imposes a burden on the consolidated fund.
Yes,
that's your clear position.
Yes,
I believe that's the position of the applicant as well. And I also believe that the position of the first defendant is that it does not constitute, if you read his...
yes.
So now we sitting here, would you...
What you said, it does not constitute...
It does a charge on the consolidated fund.
I don't think that's... he can speak for himself.
Oh, okay. So maybe I'll reserve my question for that. But in my mind, I'll reserve my question after he has, yes, so that I will articulate my points. Okay, thank you. I can proceed.
So, indeed, to assist the court, I refer the court to clause 2 of the bill, which places a collective responsibility on all organs of state, including even the judiciary and state institutions, to promote the values enshrined in the bill. Nebulous as promotion of the values of the bill is the concept, and we pointed it out in our original opinion, was still not corrected. That how is a state institution required to promote the values of the bill? Is it through education? If it is through education, it is still a constraint on the public purse. So promotion of the values of the bill required of all organs of state and state institutions will involve a charge on the procedural fund. B, the criminalization of various acts. Clearly, an enforcement of which will require the work of investigative bodies and security agencies of state in various provisions of the bill. But it is not cheap at all to prosecute. It is not cheap at all to criminalize actions and to prosecute. It may seem to be free, but it's not free at all. It's actually a heavy burden placed on the considered fund. Then the provision of prison facilities, which will be a consequence of clauses 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, and 14 of the bill. No doubt will require a charge on the considered fund. Again, there is also a duty placed, I would say a power which has been conferred on the minister responsible for culture in consultation with the ministers responsible for health and gender and children and social protection to make regulations in the bill to regulate various matters provided by the law. It may seem to be an act that is exercised in respect of other laws, making of regulations by ministers. But the point is that hitherto, until recently, there was no such thing as private members' bill. So indeed, there was no such requirement.
This is the question I wanted to ask all of you, but I thought I would hold on till I had heard from Parliament whether in our constitutional histories from First Republic to Fourth Republic we have had a private members' bill such as this.
Especially, indeed, the situation is novel, and it occurred only in the life of the 7th Parliament, which was from 2017 to 2021. It was in that time that the Speaker, the former...
In the very last
Parliament.
The very last
yes,
Parliament.
Yes, that's the Speaker of Parliament, then Professor Michael Quay, quite innovatively encouraged the initiation of private members' bill, and it was the first private members' bill. It did not involve any charge of reserve fund at all.
Which was?
I forgot the time matter. I think it was not a very controversial subject matter, and for that matter, it didn't really. But there was one such bill. I believe the Council for the Affairs for that may assist the court in that regard. But the first bill was introduced in Professor Michael Quay's tenure as Speaker of Parliament. I think 2019 or so. Especially so, hitherto there was no such concern as to the implications of a bill for Article 108, because all bills emanated from the executive. So there was implied in the introduction of such a bill a consideration of the financial implications. And indeed, there was no concern, because the basis for the Speaker to exercise, or the person presiding to make a determination, did not arise, because it was from the executive. But that is why I consider this point so important, that I think the court ought to be given an opportunity of determining the issue, whether indeed there has been an infraction of Article 108 or not. Because from 1957, the provision has been present in every constitution the country has had, apart from the 1961. And the 1960 was quite peculiar, as you said. It gave somebody a life president's status. So that's quite different. And if such a question has not been determined by the court, I think with all respect, the court has to be given an opportunity. And my preference, I would say, would be for the court to preserve the status quo, determine the question, and then if the determination is made whichever way, then the nation can move on.
Determine which question? Determine the question in the substantive suit, or determine the question in this application?
No, determine the questions in the substantive suit.
The substantive suit.
So pending that, then there ought to be a preservation of the status quo for the court to give an opportunity of determining. This then also ties in with my examination of certain cases in which the Supreme Court has refused an injunction. And I'll first start with Wilford Kwaku against the Attorney General, reported in 2012, Volume 1, Supreme Court of Ghana Law Report, at page 259. It is the Supreme Court, considered by a single justice of the court, Justice Datiba, declined to grant an injunction. Because, respectfully, it was an action that related to a move to halt the creation of electoral districts under the Local Government Act. So, that was a peculiar case. There was the creation of electoral districts by the Electoral Commission, and indeed, the application was filed only or determined only in June 2012, 6 months before the election. It was had an effect on the election, prior to the election. The court in its resolve actually stated, held at page 25260, that in the interest of the public, the collective interest of the public, said that where the relief sought release as here to a public law matter, particular care must be taken not to halt the action presumptively for the public good. The action was for the public good, and therefore the court declined it. But the second case occurred in the same 2012, and that is Ransom France. As for France, number 1, against the Electoral Commission and Attorney General, was filed in July, I think it was filed in August 2012 by my good self. And the court determined it in September 2012. My the court will note, clearly, it involved the Electoral Commission. It sought to restrain the Electoral Commission from laying before Parliament regulations that had enacted for the conduct of the 2012 elections, 3 months before the elections. And for that matter, the court dismissed my application for an interlocutory injunction. I was not peeved at all. I moved on with my life. So clearly, it is only where the court considers the collective good of the nation. And I would say that in matters that border on withdrawals from the constituted fund or the use of the public purse, as I have with all respect demonstrated before you, the collective good actually will be in respect of holding a status quo for the court to indeed determine whether the bill that is being sought to be, for want of better expression, rushed is in the public good or indeed affects the public purse. If the bill affects the public purse, then with all respect, the court owes a duty to halt the progress of that bill. I would also quickly address the point that this is actually not a case where the law in question is at its formative stages or going through the processes in Parliament. Indeed, all the processes in Parliament have been completed. Parliament effectively has concluded the processes. And indeed, now, if what is supposed to be transmitted to the President will actually be titled an act, it is just to the signature of the President and then to become law. And I would say that, having regard to the completion of the processes in Parliament, what Parliament has done will constitute an act under Article 2, Clause 1, Paragraph B of the Constitution. That is an act, a small act, not the act with a capital A, Act of Parliament. It is an act with a small a, which is an action or a decision.
And so your presentation or your submission is that the jurisdiction of this court has been properly invoked?
Yes,
for this application or for the substantive action?
Pardon me?
For this application or for the substantive action?
Oh, I'm only saying so because of the requirement in injunctions to show the existence of prima facie case as well as a substantial important question of law.
I think, can you clarify that point? I think I missed it. You are saying that Parliament has completed its processes, its procedures, and then what they are seeking to do is an act that's beyond its proceedings.
No,
but
I'm saying that now we can actually find an act having been committed, and the act has been committed. In fact, 2 acts. First is the opinion of the person presiding, which in itself will constitute an act. The determination by the person presiding will constitute an act by the person, not an act of Parliament. So once there is that act committed, it can be basis for the invocation of the court's original jurisdiction. Secondly, the completion of the processes in Parliament pursuant to the exercise of that discretion by the person presiding by Parliament will also constitute an act that can be brought within the premises of Article 2, Clause 1, Paragraph B. And indeed, I just want to have to emphasize that it's not an act of Parliament I'm referring to. It's an act as in a decision or a step by a person.
To help all of us, I think that I want to read 2(1)(a). A person who alleges that any act or omission of any person is inconsistent with. This is what you mean. Attorney General?
Yes, Mr.
Any act or omission.
Yes, Mr.
And your submission is that there is an act.
As in an action by a person, yes.
And there are 2 acts actually.
Yes.
This is your submission.
Yes,
the first act is the determination by the person presiding. And the second act is the completion of the proceedings.
Processes in Parliament. Mr. So I pray to rest my submissions, except as the court may have some questions. If the court has no questions, may I rest?
understand you clearly, your position is that we hold matters in abeyance to abide the outcome of the hearing of the substantive suit because of the gravity of the issues that have been raised in this application.
Yes, Mr.
That is what you are saying.
Mr. Referee, that's so.
Okay.
So, because it's quite new, and the court ought to be given an opportunity of efficiently determining it. Yeah, there we go.
Because this is the first time like this sort of action has occurred.
Yes, Mr. Referee, that's so. Since 1957. Indeed, even in Kwaku and all, the questions really were not so novel. I remember even filing an action in 2011, Akutu against the Attenjura, Bafos Akutu against the Attenjura, in which I raised the propriety of the case of distress by the Minister of Local Government there. So those cases were really didn't really raise any new questions as this one.
And whether or not under Article 108 and the parallel provisions previously, there's a deliberate intention by the framers of the Constitution to centralize the management of public funds.
That's right.
That would be the framing of the question that you invite the Supreme Court to do.
Yes, Mr. Referee, that's so. I will not even go into the human rights arguments. Properly speaking, we can even contest at the High Court the human rights, which is not really for this court.
Thank you.
But AG, before you sit down, it is your case that there was no determination by the person presiding that it was going to be a charge on the consolidated fund. Don't you think that is an omission itself?
Well, Mr. Referee, yes, I really recognize that if there was no such determination, then it would be an omission.
Under Article 2.1b.
But I would be hesitant in saying so because I would say that there's no evidence of such exercise.
Thank you.
As a lawyer, I would say that there's no evidence of such an exercise. My lawyer friend asserts that there was such determination. I would say there's no evidence of such determination.
So sorry. You've heard the broad scope of all the submissions. Yes.
We are vehemently opposed to the application, including the supplemental arguments made in support of it. My lords, the first ground upon which we are opposed to it is that this application is the same application that was previously brought before this court.
I think the submission made by counsel for applicants was that they've been changed circumstances.
I will deal with it.
All right.
I'll deal with it. And my lords, we have deposed to it elaborately in two main paragraphs, actually more than that. Paragraphs 11 to 16 of our affidavit in opposition. Paragraphs 11 to 15 of our affidavit in opposition. 20 page 1 to leave of record, yes. That's it.
It's 11 to
15. My lord's attention is drawn specifically to paragraphs 11 and 12 of that same affidavit. In those two paragraphs, we take time to break down the arguments made in the earlier application and compare them to the present application. And we reach the conclusion that it is the same. Now, I'll deal with the additional aspect. It says that the only difference between this application and the previous one is that there has been a continuation of the legislative process, which is that it has reached a different stage. But in the previous application, our answer is simple. In the previous application also, it sought to injunct a particular stage of the legislative process. And our affidavit in opposition attaches the previous application, which merely sought to restrain Parliament from proceeding with the bill. And we say that it doesn't matter that this time you are saying that Parliament should be stopped from transmitting the bill because Parliament is still proceeding with the bill. That is the simple answer to that, this supposed new fact.
So the first time it sought to injunct Parliament from proceeding with deliberating, and this one is seeking to injunct Parliament from transmitting.
Actually,
that's the difference?
Yes, my lady, it doesn't add deliberating. It just says proceeding.
I'm evaluating.
Very well.
So I'm asking you.
Yeah, it only says proceeding. And proceedings would include deliberations as well as continuing with this duty to transmit it to the President. And so it is not a different application. In respect of that application, so in substance and everything is the same. In respect of that application, this court on the 19th of July 2003 made specific findings and held as follows. In fact, an enhanced panel of this court said, we have considered the merits of the application before us. It is our considered opinion that a prima facie case has not been made. So first of all, on the same arguments and substance, the court made the finding that no prima facie case has been made out. The court made a further finding that no irreparable damage has been established by the plaintiff to warrant the grant of the injunction. And I'll go back to some of these facts.
Mr. Sir, before you proceed, I just want a little clarification. Yes. Are you saying that we are bound by this interlocutory decision?
You should generally be bound by it, especially that it was an enhanced panel of the court.
Is that the position of the law, that in interlocutory matters we are bound by a decision?
Well, my understanding of the position of the law is that the court is bound by its decisions on principles of law. And if the court decides that in interlocutory matters it's not bound, I will at least persuade you with it, because I don't see that distinction clearly in my reading of the Constitution.
From what you are saying, you appear to be urging us to consider ourselves bound by this decision. That is why I have a little problem.
Yeah, maybe let me urge.
Because if there's a principle of law that you want us to be bound by,
yes,
then please articulate that particular principle of law from this decision.
Very well.
That you think we should be bound by that principle.
I'm most grateful, my Lord. The principle of law is that the three-way tests established by this court in the so many lopsided decisions of the court in matters like this say, first of all, that you should establish a serious issues of law to be tried by the court. Secondly, you should show that
the just factor.
And then just and convenient. Very well. And this court reiterated in the same case, on the same facts, the same principles, applying it to the facts, which are the same as now. And so if the court even decides that it's not bound by its previous decisions, delivered by an enhanced panel in interlocutory matters, I will urge it on the court that there is nothing new in this case that will justify that departure. I'm most grateful for giving me the opportunity to clarify this matter.
But Mr. Sorry, at that time, Parliament had not completed its work.
At this time, Parliament has not completed its work. Parliament's work includes, after the last full debate under Article 106, to transmit it. That's part of its work, statutorily and constitutionally.
So is Parliament able to retain this bill for debate, further
Absolutely.
debate?
I was going to make that point. And some of the questions that came from the court earlier hinted at that when Parliament sends it to the President has options. He has a discretion whether to assent to it or not. the president can return it to Parliament to take into account some of these arguments that they are making in support of their case, to reconsider the bill. The president has that power under Article 106, Clause 7 and 8. Then the president can even refer it to the Council of States for advice on it and tell Parliament that I have referred it to the Council of State. And so this application in the court says, no, we shouldn't even allow the president to decide whether he can engage Parliament on the very issues that his principal legal advisor could tell him that right now, tell Parliament to do this. They say he shouldn't even get there, so that he will take his advantage of his constitutional obligation.
Oh, Mr. Sorry,
yes.
Let's be on the same page. If I understand, and I think I do, the applicant and the Attorney General.
Yes.
In fact, the Attorney General presented an enhanced position.
Yes.
The Attorney General identified, or the applicant said, that there has been a violation of the Constitution.
Yes.
It started when the deliberations started without the fiscal impact analysis.
Yes.
And that violation more or less was completed when Parliament got to the end of its work without still having the benefit of the fiscal impact analysis. And then he also pointed out that even in the submission that there had been the consideration required by Section 100 of Act 921, what you attached is an extract of the LI, but not a fiscal impact analysis.
Yes, ma'am. Valerie.
If I may complete.
Sorry.
Then the Attorney General went on to say that there were two acts within the genre of Article 21B Acts. And these two acts is that one, the person presiding did not make a determination, and that determination should be made from objective indices. And the second act is that Parliament completed its deliberations, ended with a bill that's ready to transmit without the fiscal impact analysis. So the person presiding did an act or an omission or both, and Parliament itself as an institution did so. I think that that's the submissions that have been laid on the ground.
Yes, my lady. And I say it has always been the same submission. The reason why they came to this court, first of all, was that that determination was not made. That was the point that has always been made, first of all. Secondly, the argument that no determination was made was previously even made by the plaintiff in the plaintiff had in the earlier application said that by failing to expressly state and record the reasons for proceeding with the bill or otherwise, a decision had been made by that. And that, I'm sure that's a question that my lady to your left was asking, that could in other ways, could we will not accept an omission or a conduct that suggests that that decision was taken, except if we see it in writing. And I'm saying that throughout the history of parliamentary proceedings, in respect of the constitutional provisions that reflect this constitutional provision which has caused this suit, the question is whether it is always the practice for the person presiding to make that determination in writing in respect of every bill that comes to Parliament. The practice is that doesn't exist. In any event, I want to look at the rules.
Council, have you even stated that in your affidavit, that practice that exists, for them even to have an opportunity to rebut it?
We have.
You are just putting it out right now and from the bar, and I think that's.
I will answer that. My lord, in the plaintiff's arguments, the plaintiff strayed into the statements of case that were earlier filed, including affidavits that this court had impliedly struck out, and then even ordered me to file the present one on which we are dealing. And I'm speaking from the same statement of case. That very well. My lord said they didn't have it, but that's, I'm responding to that point. And my lord, let me just go ahead and make this point in respect of the provision itself. It's where he made it actually. My lord said you didn't have it, but I was responding to that. The provision says this: Parliament shall not, unless the bill is introduced or the motion is introduced by or on behalf of the President, proceed upon a bill, including amendment to a bill that, in the opinion of the person presiding, makes provision for. Throughout the submissions, I've not heard the point made about the meaning of makes provision for. The question is that the submission I'm making to the court is this: all that the person presiding is required to do is to find out whether the bill on the face of it makes provision for. That is the meaning of the rule of the constitutional provision. So,
I'm sorry. This is how we should construe Article 108(1).
No, the submissions that we're making all said that it imposes on. It imposes. It imposes. So is their reading, and if you listen to the submissions of even the Attorney General, it is to the effect that it's likely to impose because of the following consequences. But the question is that the constitutional provision? Is that the wording of it? That is not its wording. So it is okay if they say it is likely to, or it has the effect of. That I can relate to that argument. But are we still construing the provision or saying that when the court comes to deal with the substantive matter, the court should consider reading it in a particular way to give it that effect? That is a totally different submission. And I am also submitting to the court that let a clear distinction be drawn between an act of parliament that it is alleged has not been complied with, as distinguished from a constitutional provision that has been violated. So it is not right in invoking the court's original jurisdiction, which is to determine whether a constitutional provision has been acted in contravention of, or there has been some conduct that is inconsistent with it, to say that, oh, let's go and understand that constitutional provision by bringing provisions of a statute, which, as we speak, is being litigated by the same parties in the High Court in respect of the fiscal impact analysis under Section 100 of the Act. That matter is before the High Court as we speak.
I'm sorry, you've lost me on the points you are supposed to have made just now.
Very well, very well, very well, very well.
You would have to reiterate it.
Yes, very well. So the first thing I said in relation to Article 108 is the fact that all the submissions I've heard so far don't address that key phrase, makes provision for. So does the Act make provision for? Indeed, in response to a question to the Attorney General about private members' bills being introduced, the Attorney General said he recalled one in the past. And I believe the one he recalls is the one that had to do with the Road Traffic Amendment Act. That also included provisions with the likelihood of people going to jail. It was a private members act. It was assented to, and we didn't have these issues. And so, my lords, I'm urging the court to follow its previous decision where it laid it down that presumptively, the court will not injunct this process, which has not reached a point there's nothing dire in it, because the president may exercise his various options to get what their very issues that they are articulating before the court addressed. At the very best, they should submit it to the presidency. They should not let this court arrest by way of an injunction that process.
But Mr. Sorry, I recall presiding over that matter. So yes, I can actually tell you what went into that decision, which is that the matter was still in Parliament.
Yes.
And whatever it is we were being asked to consider in relation to Article 108, it could be cured. It could be cured. Right now, you have completed your processes and you have a bill. Is it your submission that it can still be recalled for the purpose of curing this alleged omission?
Certainly, and that's exactly what I've been saying. So first of all, it is still in Parliament because by virtue of the pending process, the President has not accepted
That's
it.
why they're saying that. That's why they're saying that we should use our power to keep it with you until you correct what you have done.
And secondly, I'm saying that the concerns they are raising.
Do you understand?
The concerns they are raising are matters they should send to the presidency. If it gets to the presidency, the constitutional provision that requires Parliament to mandatorily at this stage not be keeping it with Parliament, but to send it to him, allows him to take into consideration their proposals and send it back to Parliament for reconsideration, and Parliament can incorporate it.
I think
that is the constitutional.
I think the point my Lady Chief Justice is making, that they are alleging a grave violation of the Constitution, in the sense that something that ought to have been done before this bill was, as it were, completed, was not done. You understand? And they are asking this court, because of that, to take a decision and restrain Parliament from proceeding to perpetuate an act which constitutes a violation of the Constitution. You are saying that they should rather take it to the presidency for whatever remedies that they can obtain there. And my lady is asking you, what if it is a matter that constitutes a grave violation of the Constitution? What prevents us, as the apex court of the land, from taking the decision on it? That is the question we want you to address.
Very well. 3 answers. First of all, there has never been anything like, our constitutional history doesn't admit of anything of like an infinitesimal violation of the Constitution. Every violation of the Constitution is grave. 2, this is an alleged grave violation. They put the tag grave violation. I'm saying that they
put the tag novel.
Well, it refined to novel, and in many instances, if not in all instances, the matters that come here are novel, because if they were interpreted, we will not become accept Article 185 or so. Was it 181 clause 5? It has come here a number of times, but the court has said that if this court has determined a matter before, don't come back here. It will be enforced by the lower court. So as for novel, grave, all of that, it is not a ground at all. It shouldn't even be canvassed in this court. As if to suggest that, some of them, we could just treat them with levity. I will get to the cases that he cited about, some involving the creation of new districts. What is happening at SAL? So there will always be these matters, and there will not be little. In any event, we say that nothing irreparable will happen if this court does not. What this court rather is invited to do is to do something that I don't think is constitutional, because it is a process that must be followed. And all of the things that they are urging on this court are capable of being decided and determined and catered for in that process as we speak. Why are they thinking that, in fact, the key question that came from the bench, which still hasn't been answered, is why don't we trust, and the Constitution has given the power to do it, why don't we trust that the President will do it? Unless there's no such allegation too. So, in every way, there's nothing new in this particular matter.
But the issue, Mr. Sorry, the issue is, do you, your client, Parliament as an institution, if Parliament as an institution agrees with them that there is a missing vital link in the considerations they should have done, why should it allow this court and allow the executive and allow the country to be expending energy on this question? If you agree with them, correct your omission. If you don't agree with them and you insist that you have done all that needs to be done, then say so. But you can't present a vacillating position that even if there is a gap, it can be fixed between the two institutions. has there been a violation or hasn't there been a violation? If you agree there's a violation, can you go and fix your violation? If there hasn't been a violation, can you say so? So that there's a determination of that.
Very well. I think that is the point where I lost you. The submission I made to this court is that there is no violation. And I read the rule saying that does the bill make provision for? All I hear is that it is likely to have the following impact. Does it make provision for taxation? Or does it have a provision which says, in respect of this particular matter, it should be charged on the consolidated fund? It doesn't have any such provision. All they submit to this court is that there is a likelihood that that will happen. And I'm saying there is no such violation. Indeed, I have attached to my affidavit in opposition Parliament's reaction to the Attorney General's position. The current one, the prevailing one, filed on May 20th, 2024, SB 3. And I've referred in my affidavit particularly to paragraph 7.13 at page 8. So all of his impact analysis issues he's talking about. Yes.
You are speaking about your affidavit in opposition of 20th May?
Yes, my lady.
It's made up of 7 pages.
No, my lady, there are exhibits.
Which exhibit?
This exhibit 3.
Exhibit 3.
Yes, my lord has found it.
Yes, okay. Please go on.
Yes, so my lords realize that in paragraph 7.13, Parliament's committee notes that the committee wishes to indicate that the concerns of the Attorney General have been taken care of in the committee's proposed amendments. That is very clear. That all of the issues that the Attorney General said, he advised them on, Parliament did. The court is referred also and the court is referred also to paragraph 8.2.
Short paragraph.
No,
the 3-line paragraph. Is what took care of the Attorney General's concerns.
And in that paragraph, it's a well-loaded paragraph. It says it is being. Oh wait, my lord. It says it attaches. My lord, look at Appendix A of it. They have listed all the various amendments, and actually in paragraph 8.2 also it says, in the light of the above constitutional imperatives, the committee decided to seek the opinion of the Attorney General and Minister of Justice on the bill. The Attorney General's concerns were duly considered. I think we should trust Parliament too. That this is a report coming from Parliament, that these concerns that are now relied on by the Attorney General.
I think I'm understanding you in this light. You are submitting that there has been a determination by the person presiding in these clauses.
First of all, yes. Secondly, their contention based on the clear tenor of the rule cannot be correct. Thirdly, all of these matters can still be taken care of in the legislative process.
This is where I come back to my position. I have one position. Have you contravened? If you have contravened, you want to go and repair? And if you haven't contravened, say so that don't push us into writing. We start here. It's 12:30. If you haven't contravened, have a firm position on that. Yes, then we know what to do.
That is so. And there's a report from Parliament which confirms that. And they've not spoken about it.
Sorry, I'm sorry. Let me just ask. The Honorable Attorney General was talking about a process which is ascertainable.
Yes.
You understand? Now, what can you put before this court to satisfy us, to enable us ascertain whether the constitutional duty that was imposed on the person presiding had been duly complied with? What evidence do you have in your processes?
Exhibit 3 is clear.
Which one?
Exhibit 3, the one that I've just read to you, said that it's in reference directly to what the Attorney General put before Parliament. It says that.
But Mr. Sorry.
Yes.
If you look at 7.1.3.
Yes, my lady.
The committee wishes to indicate that the concerns of the Attorney General have been taken care of in the committee's proposed amendment.
Yes, my lady.
If I have concerns and I convey them to you, should you say that you have taken care of them so I should be satisfied?
Very well.
Or I should be satisfied by what you have done, that my concerns have been addressed, in which case I will stop complaining.
Or you should show me what you have done, rather than tell me that you have done it.
My lady, between Parliament, which has the power to decide or to proceed in the manner in which it is proceeding, and which had no obligation to, even in terms of the legislative process, to seek the Attorney General's opinion. It sought the Attorney General's opinion and assured the Attorney General that yes, I have satisfied your position. And that's the last point between the Attorney General and Parliament.
But if you say you have satisfied the concerns of Attorney General, how?
In terms of their proposed amendments.
Mr. Sorry, respectfully, this is the bone of contention here. Here, the applicant said you should have attached a fiscal impact analysis to the bill. Then the Attorney General said there should have been a determination even on record. And third, within the bill, there are clear provisions that require a charge on the consolidated fund. And there has been nothing attached to show how the mathematics, the money, the cedis and the dollars are going to be determined, and that this is the requirement. Is it your suggestion that the arithmetic is not a requirement?
It is, first of all, not a requirement. It will only be a requirement if, first of all, the bill, the Attorney General had got up and read part of the bill, which showed a charge on the consolidated fund. And I've made this argument so many times, that the reading of the rule does not require what the Attorney General and the plaintiff are saying. It says if the bill makes provision for. So it would have even been a point to consider if the Attorney General had read one part of the rule to say which of them imposes a charge on the consolidated fund, in order for us to even to go into a further interrogation of this matter.
We will wait for your submissions on that in the substantive action.
Very well. And my Lord, this court made that determination in the same application that came before this court, that it will rather abide the substantive hearing of the matter in order for us to go into these issues. So that is the first point. And I'm saying, in any event, the legislative process doesn't end with the full and final debate. It still continues. Yes, because the bill could still come back to Parliament based on all of these arguments, brilliant arguments that have been made in this court. It could still come back to Parliament. And so it will be a presumptive injunction at the moment, because the process hasn't been exhausted to where all of this cannot be done, even if they were not done. That is the point that I was making. I've always been making. That first, the provision doesn't say so. Two, assuming without conceding, Parliament still retains residual jurisdiction to deal with that. If he thinks that his opinion with Parliament says it has dealt with, has not been dealt with, he should advise the final person to refer it based on this, because he didn't take into consideration that. But at the moment, we'll be presumptively injuncting something that has no likelihood even of perhaps of becoming law whatsoever. And the questions that earlier came from the bench were quite clear.
So, Mr. Sorry, if I get you right, the legislative process comes to an end only when the president signs the bill into a law.
Yes, my Lord.
If he doesn't sign the bill into law. It's still in the process.
Absolutely. It's in the Constitution, Article 106, Clause 8. It is clearly stated that the President can decide whether to assent. He has 3 options. Either to assent or take it back to Parliament and say, Parliament, look at the following provisions. They impact the consolidated fund. So can you amend them? And Parliament has an obligation to look at it. Or it could even decide that before taking it back to Parliament or sending it back to Parliament, consult the Council of States. So all of these options, the plaintiff and the first defendant, they are not satisfied. They say, oh, let's assume that that process will still not be done. Let's assume that even when I advise, as the principal legal advisor of government, when I send my arguments to him that even though I had advised Parliament said they had done what I said they should do, but didn't do it. So tell them to go back and look at it. The position now is that let's presumptively injunct the situation. And the string of authorities that have been before this court, starting from the Wilfred Kwaku to Ransford France to Haruna Idrisu and
Mr. Sorry.
Yes,
Mr. Sorry. If you want to cite a case, kindly do so that we can consider it.
Oh, very well.
You know, for instance, Wilfred Kwaku was cited.
Yes. Ransford France was cited.
So if you want to add to the cases, do so.
There is Haruna Idrisu and 2 others, which even makes. Yes. It is writ number J1/9.
Is this the e-levy matter?
E-levy matter. I can cite it as such unless you give me leave.
That matter has not been settled. It's only...
No, that was an injunction application that came before the court.
Wait. All right. So you are referring to the ruling on the injunction application?
Yes. In which the court even applied the presumption of regularity. There is in the Buri number 1 versus Attorney General also. It's 2013 to 2014 2 in the Buri number 1. (2013 to 2014) 2 Supreme Court of Ghana Law Report at page 1134.
Repeat the citation. I was consulting with my predecessor. Mr. Sorry.
It's 2013 to 2014 2.
adding to your options, knowing that quality and standard remains intact, and our content, which is accepted as truth and accuracy every day, is accessible on the go. Access your favorite daily graphic and our weeklies The Mirror, Graphic Business, Graphic Showbiz, Junior Graphic, and Graphic Sports on Graphic News Plus app. It's the digital replicas of our work. Download Graphic News Plus app on the Google Play Store, Apple App Store, and available on www.graphicnewsplus.com as you remain abreast of and keep pace with on-the-minute news updates on the go. Home sweet home. Welcome family and friends. Choose the bundle that best works for you from as low as 10 Ghana cedis weekly for unlimited access to all publications. Graphic, truth and accuracy every day. Great source of power, adding to your options, knowing that quality and standard remains intact, and our content, which is accepted as truth and accuracy every day, is accessible on the go. Access your favorite daily graphic and our weeklies The Mirror, Graphic Business, Graphic Showbiz, Junior Graphic, and Graphic Sports on Graphic News Plus app. It's the digital replicas of our work. Download Graphic News Plus app on the Google Play Store, Apple App Store, and available on www.graphicnewsplus.com. All publications, graphic, truth and accuracy every day. Information is a great source of power, adding to your options, knowing that quality and standard remains intact, and our content, which is accepted as truth and accuracy every day, is accessible on the go. Access your favorite daily graphic and our weeklies The Mirror, Graphic Business, Graphic Showbiz, Junior Graphic, and Graphic Sports on Graphic News Plus app. It's the digital replicas of our work. Download Graphic News Plus app on the Google Play Store, Apple App Store, and available on www.graphicnewsplus.com as you remain abreast of and keep pace with on-the-minute news updates on the go. Home sweet home. Welcome family and friends. Choose the bundle that best works for you from as low as 10 Ghana cedis weekly for unlimited access to all publications. Graphic, truth and accuracy every day. Information is a great source of power, adding to your options, knowing that quality and standard remains intact, and our content, which is accepted as truth and accuracy every day, is accessible on the go. Access your favorite daily graphic and our weeklies The Mirror, Graphic Business, Graphic Showbiz, Junior Graphic, and Graphic Sports on Graphic News Plus app. It's the digital replicas of our work. Download Graphic News Plus app on the Google Play Store, Apple App Store, and available on www.graphicnewsplus.com as you remain abreast of and keep pace with on-the-minute news updates on the go. Home sweet home. Welcome family and friends. Choose the bundle that best works for you from as low as 10 Ghana cedis weekly for unlimited access to all publications. Graphic, truth and accuracy every day. Information is a great source of power.
Has jurisdiction over the matter. Lord, my fourth concern with respect to the affidavit of the first defendant in opposition has to do with paragraph 19, in which he states, and again with your kind permission I read, in respect of a prima facie case, the court in another suit which raised the same issue based on the same facts as the plaintiff's present case held that the plaintiff's case disclosed no prima facie case, the present case not making a case different or better than the one earlier dismissed by this court. We have painstakingly procured a copy of the order of the court in Dr. Amanda Odoi versus the Speaker of Parliament and the Attorney General. And Lord, it's a very short reading, a very short order, which if permitted, I may read to the court.
Yes.
It goes as this. We have considered the merits of this application before us. It is our considered opinion that prima facie case has not been made to convince us to restrain the Speaker of Parliament to restrain the work of Parliament in its uncompleted form. Neither has there been a case made to convince this court of irreparable damage to warrant the grant of injunction to restrain uncompleted proceedings before Parliament. This court is unable to injunct. The difference between this case and that of the earlier decision with respect, my lords, lies in the fact that the bill has been completed. Deliberations over the bill are over. All extenuating factors have been taken into consideration in concluding the bill. And it is premised on this, that in the earlier suit when the bill was not completed, this honorable court held that once the bill has not been completed, then no irreparable damage to warrant the grant of injunction coexist. Lord, that is totally different from what we have before you.
Point noted.
Very well. Lady, to make it much more snappy, we've looked at paragraph 6, which is an argument already put before the court, and we are only rehashing. We've looked at paragraph 23, which says that at all times material to the application before the court. Also, a physical impact analysis of the bill has been undertaken, a copy of which is exhibited hereto. The emphasis is mine. A copy of which is exhibited hereto and marked 4. Lord, we've painstakingly looked at that exhibit 4. And it is nothing but LI 2376, Public Financial Management Regulation 2019. Our contention here is that that paragraph is very misleading. What is attached as Exhibit 4 is not an FIA, it's not a financial impact analysis report. It is rather a subsidiary legislation. Lords, Section 100, as has already been emphasized in the earlier submission in the earlier case, indicates clearly that every bill put before Parliament must be accompanied by a financial impact assessment report. And of interest to us is Section 12.1 of LI 2378, which takes the pain to define, explain, and expatiate on what constitutes financial impact analysis. Exhibit 12A, for purposes of brevity again.
Section 12A.
Section 12A, sorry. Section 12A 1A reads, provide data on expected revenues to be realized from all identified functional sources.
Counsel.
Yes, my lord.
You jumped the first part of it.
Very well.
I read from 12.1.
Very well.
Further to Section 100 of the Act.
Exactly.
A covered entity.
Yes.
Which submits a new legislation.
Yes. To be laid before Parliament.
Yes. Or a proposal for the approval of Parliament. So this is talking about covered entity.
Yes. And we are saying that.
And we've been dealing with private members' bill.
Exactly so. And
that's for you to see the difference.
Very well, Milord, I wish I complete my argument. Milord, with all respect, with all difference, we are saying that the people who introduced this bill are not ordinary citizens of the land, though they are Ghanaians. We are talking about private members of parliament. And milady, we are of the firm conviction that they fall under
covered entity.
Yes, they fall under covered entity.
I suspect the Attorney General won't agree with you.
Very well. Lady, I await his response thereof. But our concern here is that some indications are given as to what should constitute a financial impact assessment. And it reads, data on expected revenues to be realized from all identified funding sources under the legislation or proposal. And B reads, provide data on expected expenditure to be incurred under the legislation or proposal, including wages, salaries, allowances, and pensions. Milord, if you look at clause 3 to 14, clauses 3 to 14 of the Mr.
Pedro, I'm reluctant to take the shine off you, but these submissions have been well laid out this morning. And I think that you made a very valid point. That because earlier on there had been the inquiry as to what the fiscal impact analysis should contain. And you have drawn the attention of the court to section 12. I think that regulation 12, I'm sorry. But so that responds to the question.
Very well. Lady,
you are not done.
No, I'm rounding off. I'm rounding off. Kindly.
Yes.
Lady, all said and done. The first defendant at paragraph 20 of his affidavit in opposition refers to the letter from the Attorney General or the report from the Attorney General to the Constitutional, Legal and Parliamentary Affairs Committee of Parliament.
We are waiting for you.
In which the Attorney General expressed his reservations about the bill. Milady, the Attorney General, in his submission this morning, has clearly indicated that those concerns raised by him were not corrected or factored in the bill before attempts to transmit.
I believe that at this moment, the issue is whether Parliament should be injuncted.
Exactly.
You sued Parliament.
Yes.
Dr. Amanda Udoi sued the Speaker. So whether Parliament should be injuncted from transmitting.
Exactly.
Yes, this bill.
My lords, with respect, we see the Speaker as the embodiment of Parliament.
Yes.
So when we talk about Parliament,
yes.
We are
why should we restrain the transmission? In the earlier submissions, the Council for Parliament, who is still the Council for Parliament in the present case, clarified that the President has 3 courses of action. And so if the President agrees with your submissions, with whatever is being said in this court, his lawyer or advisor is the Attorney General who is in court. The Attorney General could advise him to send it back to Parliament for whatever is deficient.
Lady, I state with reservation that...
So this court should not interfere?
Lady, I state with reservation that so far as we are concerned, an advice always remains an opinion. The final decision lies
GBA versus Attorney General.
Exactly. So, milady, it may be taken or not taken. And this is the more reason why we safeguard ourselves under the Constitution by seeking an injunction. Lady.
Counsel.
Yes,
in the transmission process, does anybody exercise a discretion which you can stop?
Lady, the right to come to court is an inherent one in every citizen of the land. And lady, our concern is that going by Article 18A11A, Roman number 2, which has already been alluded to before this court, lady, there was a fundamental breach of the Constitution in the Speaker's admission of the bill in the first place to deal with. And on that score, on the strength of Article 2:1, any citizen of the land will be at liberty to seek redress before your lordship.
And you are done.
This is the more reason why we believe this is a proper ground for this application to lie. I rest my case.
Thank you, sir.
Lady, we agree in totality with the submission made by the Attorney General. That is the
Attorney General says he doesn't want to be
No, I agree. I agree with every submission he's made. In fact, he's rather complimented our submission. So we have no cause to object to anything he has stated.
Attorney General,
let me rely on our statement.
I believe that you rely on your submissions in the current case will be totally in tandem with what you have already said.
Yes, it's my indeed that's so. And I don't want to bore the court with a repetition of those arguments. So to develop just one point, the facts about the prohibition that I stated is implied in Article 108, the prohibition on Parliament from proceeding with the bill. I argued fully on that, but I'll develop the argument further by stating that prohibition on Parliament from proceeding unless certain factors have been met actually implies a condition precedent to Parliament's power to act upon such a bill at all. My lady, I will state further that indeed that prohibition actually then operates as a fetter on Parliament's power from proceeding because it's a condition precedent. Without the satisfaction of that condition precedent, every step taken by Parliament is null, void, and of no effect. And respectfully, if that is the case, the question arises whether indeed
there's even a bill.
There's a bill at all. Or there can even be a cure, a remedy for the default of the Speaker of Parliament in proceeding. Early on, my lady would observe that I actually made a point in answer to a question from the court that I would be hesitant in stating that the Speaker did not make such a determination. And I would rather say that there was lack of evidence of such a determination. Clearly now I've seen evidence of the omission. So I would amend my earlier submission to say that the Speaker actually omitted because there has been such clear concession by the first defendant in his statement of case where he stated that the Speaker did not present such a determination at all. Already I will state that so clearly there was no basis on which Parliament could proceed because there was a failure to satisfy the very important condition precedent of the Speaker or the person presiding, presenting an analysis of the impact on the consolidated fund. And simply, I would further submit that such an omission cannot be cured by the President's election to refer the bill back to Parliament for reconsideration. Indeed, what if the President does not refer the bill back to Parliament? It means the nation lives with their own constitutionality. That would clearly be the implication. If the President decides not to present the bill back to Parliament, the nation will live with such unconstitutionality. And that will be a huge scar on the constitutional landscape of the nation. Especially, I submit that there's again no independent power of Parliament to reconsider a bill after the processes in Article 106 of the Constitution have been satisfied, which indeed have been up to this stage. Parliament has fully exhausted all the processes of considering a bill. The bill has been introduced in Parliament, has been read for the first time as required under Article 106, Clause 4 of the Constitution. It has been referred to the appropriate committee of Parliament under the same Article 104, Clause 4 of the Constitution. There has been a deliberation. There has been a deliberation upon the bill by the appropriate committee as required by Article 106, Clause 5. Indeed, the bill has been read for the second time. It's been subjected to full debate as required by Article 106, Clause 6. And indeed, it has been read for the third time. It has been passed by Parliament. Especially, my submission is that upon the satisfaction of all these steps required under Article 106, there is no room for Parliament on its own to reconsider such a bill. And therefore, there is no provision for a remedy or a cure of a failure to comply with Article 108, paragraph A of the Constitution.
Honorable Attorney General.
Yes, especially.
Did I hear you say that after a bill has been assented to and it's become an act, that there's no other opportunity to take the matter on?
No, it's definitely not.
I didn't.
No, it's
I
definitely
didn't
not.
hear you right.
No, it's definitely.
I am
the
glad.
point. Yes, definitely. The point I made is
Even on closure at the bill stage, Parliament's rights are exhausted, or Parliament's capacity, authority is exhausted.
Yes, that
and
at the stage
and cannot receive the bill
on its own.
On its own.
Yes, that at the stage we are, Parliament's power to independently review the bill or provide a remedy or cure, as earlier on advocated by my learned friend, does not exist.
No. What your learned friend is saying, which I think is compatible with what you're saying, is that it is the president who can tell them that there is this defect, and so cure it.
Right.
Yes.
And then he also
and Mr. Abedu says that supposing the president doesn't do that, the nation will have to live with an unconstitutionality.
Precisely. And that's the point I make, that indeed, so it is up to the president to do that. And I respectfully made the point that at this stage, Parliament cannot independently do anything at all. And if the president also does not elect to refer the bill to Parliament or even to Council of State, then the nation lives with their unconstitutionality. And I made the earlier point that it will be incongruous for Parliament or the nation to be, for such a bill to be foisted on the nation purely on account of an omission of the Speaker of Parliament to undertake an act which is required by Article 108, Clause 8, which is make a determination, which clearly is not in doubt at this stage.
Honorable Attorney General, do I understand you to be saying that if you, as legal advisor of the government, if you offer an opinion on something, the government won't listen, the president won't listen, and will sign anyway, even if you tell him, no, don't sign this one?
No. That's the point I make. That is why I preceded my arguments in the other matter with on the basis that indeed I made all these submissions, not to assist the court to determine the case. It is to settle a question. And the question I respectfully want the court to settle is whether indeed a bill passed in flagrant violation of Article 108, Clause A, which enjoins the person presiding to make a determination, is valid or not. But the issue for me goes beyond the substance of this bill. So indeed, we must look at, with all respect, the bigger picture. That now private members' bill has come to live with us. Every day, things are coming up and all. Even now, there's actually a dispute as to whether a bill that has been passed and assented to by the president is actually constitutional or not, which is the Witchcraft bill, also amendment bill or witchcraft bill, which again the president actually sought to recall, because indeed after that bill was assented by the president referred it to the Office of Attorney General for advice. And I said that no, it clearly held implications for the taxpayer because it implied violation of Article 108. And then the president sought to recall his assent to the bill, and it created a very huge chaos. So essentially, I would entreat the court to indeed deal with this issue quite seriously. And
you said you will entreat us not to injunct, but to hold the status quo.
Yes.
Now, are you inviting us to injunct?
Oh, so it's the same. I think the import will be the same.
You are vacillating.
Okay. No, I think the import or the effect of holding a status quo pending the determination of the action will be to prevent the bill from progressing.
Do round up.
Yes, but the point I think maybe I ought to clarify that point. It's very important. Maybe that's the point of which I'll end. That indeed it is important for the court to settle this question, to be given the opportunity of settling the question, and then pending the settling of that question or determination of that question by the court. I think that the parties ought to hold their hands for the court to be given an opportunity. I believe that brings greater clarity to the Honorable Lady Chief Justice.
I'm not done, and some new information has just come to me in the short break, which I'll make available to the court very soon. But most importantly, I need to react to a few points made by counsel for the plaintiff and also the Attorney General. The point about whether if this bill ripens into an act, the whole nation is forced with an unconstitutionality doesn't arise at all, especially even in the context of the instant application. I cited the case of Commission on Human Rights versus Attorney General to the courts. 1998 Supreme Court of Ghana Law Report, page 894. Justice Hifron Benjamin took pains to explain this point, that especially when a lot of your reliefs, final reliefs, are declaratory in nature, the court is even more reluctant to intervene by way of an injunction, because at the end of the day, the act will be declared null and void. And so then also there's this argument which also corroborates my case in terms of fact, that the Witchcraft Bill has come back, that the Witchcraft Act is now even back for a determination of the question as to its constitutionality, all still corroborating the fact that even if we discount the options that we have now, including his own option of advising the president, I don't want to lose my lady. I don't want to lose my lady somewhere.
I was wondering if you were inviting the nation to live in a messy situation, but
there will be no messy situation.
Mm-hmm.
All of that has been anticipated by the Constitution. That certain things will be done, and this court has power to say that whatever you have done is hereby nullified.
You said that we shouldn't be coming to this court. You said they shouldn't be coming to this court. That they should be resolving the problems outside of this court because you haven't finished your work.
No, that's not exactly what I'm saying. I say I'm now responding to the specific argument that if no injunction is granted, we are totally helpless at this stage. I'm saying that even if we speculatively decide that the president won't consider any of the options available to him and won't even listen to the Attorney General's own advice, the final reliefs of this court say claim declaratory reliefs. And the Commission on Human Rights case that I've cited to the court says that to the extent that that can eventually be nullified, the Ghanaians are not damnified. And finally, I am sure he knows that under Article 58 of the Constitution, the president has a responsibility of upholding the laws of the Republic of Ghana. So if he draws his attention to that fact,
everybody, including us.
That is so. But we are
including the Speaker.
We are oh yes,
including Parliament.
Oh yes, that is so. But there is a specific provision which deals with the president in this particular matter, and I'm saying that as the first man of this country, if his Attorney General draws his attention to an unconstitutionality, he would definitely take every step to correct it. So we are not helpless at this stage, the way they want it to look like.
Very well. Thank
you. Then there are some specific references.
That is the last one.
I think, that can't be the last one. There's a number of paragraphs have been dealt with in my affidavit that I need to respond to. The paragraph 10 that he dealt with would be answered by the argument that I've just made, because in that particular paragraph, repetition is made to the fact that the president has a discretion as to what to do with it. And my lords, I'll just crave your indulgence to read specifically Articles 106, 7, 8, and 9 of the Constitution quickly. Clause 7 says that where a bill passed by Parliament is presented to the President for assent, he shall signify within 7 days after the presentation to the Speaker that he assents to the bill, or that he refuses to assent to the bill unless the bill has been referred by the President to the Council of State under Article 90 of this Constitution. Then clause 8 says, where the President refuses assent to a bill, he shall within 14 days after the refusal state in the memorandum to the Speaker any specific provisions of the bill which, in his opinion, should be reconsidered by Parliament, including his recommendations for amendments, if any. Inform the Speaker that he has referred the bill to the Council of State for consideration and comment under Article 90 of this Constitution. Then finally, clause 9 says, Parliament shall reconsider. When it is sent to Parliament, it shall reconsider.
Where you probably missed what the Attorney General said, that the Article 108.1 provides a prerequisite action condition.
Yes.
A condition precedent, such that if missed, everything done thereafter is invalid. For legality and constitutionality.
I didn't miss that point. Eventually, if this court decides that there has been an illegality by reference to the Constitution, what it will declare is that there is a nullity. And the question my lady kept asking me earlier is that if in truth there is an illegality and Parliament concedes it, would it correct it or not? So if the President draws Parliament's attention to that, and Parliament agrees with the President, and that's it, it would have achieved the same question that my lady had drawn attention to. So again, no need for the injunction. So that's my answer to paragraph 10. Then he answers my paragraph 12 by saying that my submission, the position in that paragraph that the question as to whether Parliament was quorate or not was raised earlier. My simple answer with that argument is by reference to the Haruna Idrisu, the e-levy case, in which the question arose as to whether Parliament was quorate or otherwise. This court applied the omnia presumptu rule to it. So I'm using
the e-levy case. You attached evidence of who was in Parliament, and that evidence itself showed that there was quorum, and yet you came here saying that there was no quorum. I was on that panel. I remember very clearly.
But then they refer to paragraphs. I'll get back to that. In paragraphs 13 and 14, they answer it by saying, oh, they are coming in the interest of the public. But there are depositions in paragraph 19, which provoked those two depositions from me, refer to the fact that people were being threatened and their human rights violated. The court's jurisdiction is not being challenged to interpret human rights provisions. But insofar as enforcements are concerned, there are also two preconditions. It is the High Court which enforces such rights. And it is the persons whose rights who have been violated who have the constitutional...
I think that it's all, everybody is agreed here this morning that the fulcrum of contention is around Article 108. That is what
But I'm responding to his argument. Once he has made that point, I need to respond to it. But as for the point that the deliberations are over, I don't need to answer it again because I have made that point clear. Then earlier on, I've responded to the Attorney General's argument, so I will then deal with new information that came to me right after the court took a break. They found the Speaker's actual opinion, and they found a fiscal impact analysis. I will crave the court by tomorrow morning to file a supplementary, and that's those. I'll just attach them. That's all.
Lady,
and I'm still on my feet, unless it's on my feet.
Yes, my lady, yes.
Attorney General, kindly resume your seat so that he can finish.
And it's just information that has come. I'm not going to say any other thing apart from saying, pursuant to my promise to the court, please find attached, and then I depose to it. And the Minister for Justice can then object to the fact that he's not even interested in this information.
But you haven't even filed it. So how can you even say he's not interested?
I don't get it, my lady.
You haven't even filed it. So you need to file it before...
we have up to the 17th of June. So I was just saying by tomorrow morning, I will file it.
So I was taking you on the fact that you were saying that the Attorney General is not even interested in that.
No, he rose promptly to his feet to tell me that he's not interested in it.
My audience, that's very unfair. Yes. Just 1 minute. But it's just very unfair. Indeed, so is the process by which he's seeking to adduce such evidence. Very much unfair. Where has all this evidence been all along? He's kept it to his bosom from last year when the bill was, I think even 2 years ago. 2 years ago, when the bill was introduced to Parliament. That is when he's required to do so. We've never seen it at all. Then today, even at the time he was filing his process in court, his counsel, with all respect, made a concession that there was such omission. And then after I submitted based on such omission, he springs up and then unleashes it as a surprise on us. I think it's very unfair.
My lady, he's worked in the public institution.
I think you accept that this is unfair. But as to whether you knew it or not, you said it's new information to you.
Absolutely.
This case has been on the table. Does that mean that your researchers lacked, or Parliament's researchers lacked that much diligence?
My lady, I just got that information. I don't need to.
Does that mean that Parliament's researchers lacked that much diligence?
My lady, if that is the view of the court.
This case has been pending since last year.
He's worked for a public institution. My lady knows, the Attorney General knows the number of times we've granted them extension of time. And the unfairness will be cured by the fact that he will be served with a copy.
No, kindly round up. Yes, I don't know if I will give you leave to bring it. You may file it for the substantive action, but not for this application.
Very well, my lady. But I'll draw the court's attention to it anyway. But on the strength of even the submissions that I made, we take the view that this cannot be a ground for injuncting a process that still has several options, constitutional options available.
Thank you. So this application is also adjourned to the 17th of July. July. For ruling. Yes, sir.
Is it going to be a composite ruling, one ruling on both?
Oh no, we are unable to do that. We will give a separate rule. Of course, the second one can adopt the first one. We will refer to a ruling in the first case.
I thought that it would have been appropriate since the same facts and all.
No, we have not consolidated the cases.
Okay, yes, okay, but a ruling which...
If you like, we can repeat it. So the ruling is adjourned to 17 July 2024. Thank you. We must thank everyone for their patience, but this is a lot, right?
Options, no knowing that quality and standard remains intact and our content, which is accepted as truth and accuracy every day, is accessible on the go. Access your favorite daily graphic and our weeklies The Mirror, Graphic Business, Graphic Showbiz, Junior Graphic, and Graphic Sports on Graphic News Plus app. It's the digital replicas of our work. Download Graphic News Plus app on the Google Play Store, Apple App Store, and available on www.graphicnewsplus.com as you remain abreast of and keep pace with on-the-minute news updates on the go. Home sweet home. Welcome family and friends. Choose the bundle that best works for you from as low as 10 Ghana cedis weekly for unlimited access to all publications. Graphic, truth and accuracy every day.